Yes. Ah.
6 Max.
Oh, no mention date today. That's all right.
Lunch.
But mention is 1:30 to 2:30, right? Last only we were told today. Last week 1:30 to all right.
Medical. 6.
Medical admission.
Give it.
My lords, lunch motion was sufficient. Lunch motion. The petition.
Medical admission.
No. Exam related. The petitioner was not permitted to write the exam. Learned single judge having found fault with their action.
No, but it can come up tomorrow. What
Tomorrow is
the
the exam, my lords.
exam? All right.
Obliged, my lords. It's lordship surface petition. Surface
What is
petition infectious. Bank has withdrawn the surface proceeding. The writ itself is infectious, lordship. Bank has withdrawn the surface proceedings. To file the it may be
get it today? Yes, today. Yes. What is the date today? 4/10. In the result, writ petitions are allowed.
Well, humble submission, my lordship. Lordship, let there be suspension till the appeal time, my lordship.
No, we have given 90 days time. So there is a direction for demolition. That permit granted in your favor is cancelled. 5 and 6, you alone are directed to carry out the work of demolition of commercial complex within 90 days under the supervision of the officials of Telangana Housing Board and Hyderabad Metropolitan Development Authority. The HMDA shall nominate an expert under whose overall supervision the demolition work shall be carried out. Entire expenses will be borne by you, and 3 months time has been granted, so you have breathing time. It's not that immediately you have to do it, right? So sufficient time to find SLP. All right. Other case. Other.
Pertinent to note here that based on the complaints of the parties, the police have already registered crime 458 and 457 of 2007 at police station Banjara Hills and acted in accordance with law. And a requisition stated to have been already made to the Tahsildar for furnishing the factual report, taking into consideration an observation made by the Honorable Supreme Court in the case of Satyanarayana Tiwari that this court has ample jurisdiction to issue a writ or direction to all the authorities, including the police, to enforce and maintain rule of law, and also taking into consideration the observations made by this court while passing the interim order on 7/9/2007, these writ appeals are disposed of, leaving it open to the respective parties to make an appropriate application to the official respondent authorities, ventilating their grievance as and when such situation arises, and upon making such an application, the official respondent authorities thereafter are directed to enforce and maintain rule of law. However, it is needless to mention that if there is any civil dispute between the parties on the subject property, the parties are at liberty to persuade the remedies as available under law. In the result, the appeals are accordingly disposed of.
This you get it done before only. Instead of wasting time here, we can sign. Ah. Because until it is signed, they will not give it to them for reading.
No, I mean, it's connected to serious item number 2 and 5. Order part by your lordship.
Ah.
Same include order.
Ah.
Writ appeal number 9.
Intra-court appeal. This intra-court appeal has been filed against an order dated 10th of July 2023, passed by learned single.
May I please, Your Lordship, so I think
Ah.
it's an application for leave to file the intra-court appeal. But the earlier state of Andhra Pradesh issued a governmental order. Pursuant to
This is an interim order. You can apply for vacation of stay.
No, I'm not a party to the writ petition.
You can still apply. Same application.
But if Your
seeking
Lordship,
permission to
if Your Lordship sees the order under challenge, my Lord, the learned judge says it is not government land. My deed of conveyance itself has been challenged, that was suppressed. If Your Lordship sees the deed of conveyance, which is at page number
Ah.
209. This was challenged by the writ petitioner. He chooses to suppress this in the writ petition.
Deed of conveyance in the writ petition.
He suppresses this deed in my favor and he questions this separately. All the writ petitions were.
Or you can still file an application stating all facts that this has been suppressed. All the whether application for intervention does not lie or impleadment does not lie before learned single judge.
All the analogous writ petitions were tagged together. Suddenly they detagged and only this writ petition comes. And in this, my lord, if Your Lordship sees the writ affidavit, it is something like an injunction suit. And the learned judge says, in respect of, it is not a government property. It's a government property. That is the reason the government.
This is only an interim order. He doesn't say anything.
No, it says, the ultimate paragraph says it is not a government property, which with due respect is incorrect.
All right. Anything else?
But so wherein I have not heard and this order has been passed and not been made a party.
Yeah, heard means you are not a party. Obviously, you won't be heard.
Absolutely. And he chose.
Can single judge anticipate what?
And he chose to question my deed of conveyance on an earlier round of litigation.
All right. Mark the presence. This intra-court appeal has been filed against an order dated
subject property in EP number.
Hey, you are on caveat.
I am appearing for respondent 1 to 4 your lordship.
On caveat. We have passed an order. In case you are aggrieved, remedies elsewhere. Travel northwards.
May I make one small?
Yes.
May I make one small? Let them not do anything with the property.
No.
Much obliged. Praveen Kumar.
Wait, for my lord, if I could
Ah.
commence, Willard.
Ah.
I'm instructed to appear for the fourth respondent.
Huh?
I would request just that the matter be taken tomorrow, if my friends would serve me today.
Very well, my lords. Papers are to be served is what my senior is.
Ah.
I'll serve papers.
No, but you are appearing on caveat.
No, Willard.
Then he has to be heard on admission. How can you insist that copy be supplied to you?
I'm insisting, Willard,
Ah.
but I'm not insisting.
Ah.
However, Willard, the tradition of this court, Willard, has been that when you file a wakalat from the writ petition, writ appeal, Willard, is usually served on the other side.
Which tradition means rules,
That's been the practice. Willard. That's been the
practice.
Yes.
So as per the practice prevalent, it is stated by learned senior counsel who and respondent,
Usually.
appellant and the court, you don't file caveat. In any case, even if you file caveat, you cannot oppose admission of an appeal. And you can only say in case you file a caveat that please do not grant him interim relief
Without
unless
hearing.
I am hurt.
Without hearing.
So,
That's all.
but this is strange, right? He is yet to argue on admission. You are seeking adjournment on his behalf because he is not prepared. We don't know, like something like tacit arrangement like.
Nothing, but in fact, I have not
Yes.
spoken to him since morning.
All right, next.
Usually, we'll writ petition when the parties are.
No, that's what we, no, this is something strange. That's what we told. Like, you have not filed a caveat.
Yes.
This is the matter is yet to be heard on admission. And you are saying that I should be heard. Why copy? Because you want to be. That's why we have clarified that you don't have any right to be heard on admission.
Absolutely.
It's absolute. It's between us. Since you are present, in case we are convinced about admission, we will hear you on interim relief.
That's
Yes.
the only assist
Next.
your lordship.
Huh? Next date, he is not in a hurry, right? So list after 1 week.
Oh, that's good.
Okay. Admission.
Which one? Today is what? 4:10.
May I please?
Huh?
I'm the appellant, but I take the notice to the respondent.
7.
But
7 is done. 8.
But Lord, in this matter, I takes the notice to the respondents. Lord.
Huh?
I take the notice to the respondents. Lord, the confiscation order is set aside by the under the impugned order. Lord, that is under being challenged. Lord, the vehicle is released already by virtue of the interim order on payment of the surety
then-
amount. Lord, this order is coming in the way of the prosecution. Lord, that is the reason. Lord, the writ appeal is preferred. Lord. The learned single judge allowed the basing on the they bona fide enter into the forest and flout the 1 acre of the land. Lord. That is the allegations in the criminal
No,
prosecution.
but the learned single judge relied on a full bench decision of this.
Lord, the Supreme Court judgment is also Karnataka, Lord, the held that it cannot be, Lord, the unless until prosecution is there pending, Lord, the setting aside may impact the prosecution.
You know what? just like, I mean, this case also you have difficulty, no records. So out of this,
No,
they're just
this is
saying,
appeal.
this is, he has referred to, have you got this full bench judgment?
Lord, the,
Yes, has he not relied on full bench judgment?
Yes,
What
Lord.
is it, Mr.?
there are 7, Lord.
Hmm.
My prosecution is pending, my lord. That is the reason. These observations may impact my prosecution against their committing the forest offense.
What observation?
Lord, the court, Lord, they made observation that the bona fide they enter into the forest and they plowed the area.
So we will say that the observations contained in the order shall not, this thing,
Yeah.
shall not be prejudicial to you in, where the prosecution is pending.
Magisterial court.
All right.
Yeah.
Yes, heard on.
My please your honor, I am from appellant, my lordship. Here it is one delay petition, my lordship. It is for, as my petitioners above 70 years, they cannot able to come, they have been hospitalized. And the delay
You on merits, delay condoned, yes. What is the case on merits? Your grievance was that the petitioner has not been given an opportunity before the special tribunal. Single judge has found that you have been heard. What is there to interfere?
as my petitioners, as senior citizens, I cannot enable to walk and they're in this, my lordship, can be allowed this petition, my lordship.
This is not the argument on merits, right? Tell him, your friend, probably he will understand. Go and tell him what we are saying. Arey, Mr. Government Advocate, arey, you tell him, explain to him the delays condoned. We are asking him to argue on merits. He is saying that petitioners are senior citizen, therefore petition should be allowed.
They have been
This is the argument. I mean, like, then we will dismiss it by saying that merely on the basis of age, no petition can be allowed or dismissed, right? Then in your appeal, Mr. We should have seen the age of the officers of the forest department before passing an order. What is their age? Because he says it's so easy, right? So easy that senior citizen, all petitions to be allowed. Very easy for us.
Lordships and IA number 2, my lordship, it is set aside.
Arre, forget, Mr. The IA is allowed. We are asking him, what is the case on merits? He is unable to understand, right? Yes. All right. What can be done? Heard on IA 1 of 2023, an application seeking condonation of delay for the reasons assigned in the application. Yes. Second court, yes.
My lordship.
Let the rate petition be listed before the appropriate bench as per roster. Well. Yes, 11. 11 back.
Yeah.
Ah,
Regarding medical admission into C category seats, my lord,
huh?
petition is filed, my lord.
What?
Regarding medical admissions, my lord, the C category seats, my lord,
Hey, what is, Mr. That's why deliberately you keep the averments vague, right, in the petition. We were trying to find out, no date is this thing.
my lord,
When was the result declared?
the result declared, my lord, on
When was
But
the
why-
process, Mr. When was the process notified? How many rounds of counseling held?
three,
Why, what was the last date? Why you didn't apply?
Sir,
Nothing.
I have applied, madam. My application is at page number 12. I have applied on 7/8. The notification was given on 3/8.
3-8.
3/8.
Mr. 1 minute. Yes, Mr. Rao, what is his grievance?
Same order, madam, page 15.
Page 15.
A similar order is. Consider the representation.
That you are not saying. We would have dismissed the petition, right? Huh?
I have filed the order, madam, at page number.
Page, this thing. Yes.
May it please. I have placed before your lordships seek leave to place before your lordships a small brief note on the matter.
So which case contempt you want to be heard first?
The writ, my lords, because the contempt follows the writ.
No, but this is not for final hearing. This is for IA 7.
Yes, it's the. My
Give
lords,
that other file. IA 7. Let it.
Before my signature starts, Lord, I have sent my counter for signatures.
Counter to IA 7.
Not in main petition.
We are not hearing the petition finally. You can file counter. This is IA 7. You have filed, Mr. Rao.
I filed counter, madam.
Yes, to this IA.
yes.
What is this? Give IA number 7, madam. And order sheets. Yes.
My lords, consequent upon your lordship's order, may I first draw your lordship's orders attention to.
No, we have understood, right? The grievance is that there you have only been given the benefit of SC status and not third gender status, and wrongly admission in emergency medicine. You are entitled to a seat of your choice.
I just fine tune that argument of mine. What I'm saying is this. This honorable court, by both the orders, one passed by the earlier division bench and one confirmed by your lordships.
20th 6/23 and
20th June and subsequently on
23.
2nd August.
Yes.
What had happened is, my lords, the order was that I should be given whichever is more advantageous to the petitioner. Now, at that time when that order was passed, the university was not a party to the said order.
One thing, Mr. This thing, supposing if this, you are again seeking a direction to implement those orders, right?
No, I'm
see
saying
prayer-
earmark a specific seat.
Prayer, yes, please see the prayer clause. in compliance of the order dated so and so. So again, another IA
there-
for implementation of two orders.
To say, no, to allot a seat in so and so in accordance with the web options made by the petitioner. And this is in compliance with the said two orders.
Compliance. So these orders do not say that you should be allotted.
So that is what I'm saying. I am saying,
Gynecology.
yes, that is why the present application is to allot a seat in this subject, which is not mentioned in the earlier order. But I'm saying this will be in accordance with the orders dated so and so by this honorable court. That is the interim prayer I'm making. But the basic issue would be this, that your lordships would be.
Basic is you tell us that how you are entitled to admission in MS or gynecology.
Yes.
What basis?
My contention is this, my lords.
You are the most meritorious candidate.
I'm sorry, my lords.
You are the most meritorious candidate. That's why what is the base? We are asking you.
Lordships take the memo dated 6/9/23, which is filed along before this court. In the contempt it is filed, your lordships may take that. It contains a matrix at page 14. My lords, I'll address that merit part later, my lords, but kindly come to page 14.
No, merit means we are saying that your entitlement to admission. We can give a direction provided you are entitled.
Yes.
We are trying to understand what is the basis of seeking admission in MS.
In a certain specific faculty. Kindly come to the matrix at page 14, my lords.
14.
1-4. It's filed along with the memo.
Which memo? Dated?
6/9/2023 in
This
the
is 5th September.
contempt case.
6th September.
I can pass on an extra copy, minutes to ensure that I don't hold back the court.
So what is your rank according to you?
I rank I've given your lordships in the note that I've just given your lordship, which would be
rank? No,
rank is all India rank is 155010.
155.
And in the, I'm sorry, 100216.
100216. All right.
Well, it's you were required to provide for a specific category
That they have not done.
that they've not done. Now, if your lordships look at that matrix that I was showing your lordships, your lordship.
No, we are only currently on the interim application, how you are entitled to MS.
Kindly come to that matrix at page 14.
Page?
Now, if you're page 14.
There is no pagination, Mr. In the copy, we don't know what. 6/8 or 6/9.
6/9.
Madam, this you are giving 6/8. One memo is 5/9. And there is no pagination here, and I don't think it has 14 pages. In any case, even if we count.
6/8.
But I do not have the copy. I also do not have the copy.
Your lordships, kindly go to it at page 14.
This is 6/8, right?
6/8.
6/9.
6/8.
You 6/8, right?
6, I beg your pardon.
This is like this.
Yes, I'm of that. If your lordship see, the classification is open category general. If your lordship see the first of the verticals there. Can't be read, man. That's the way it's. OC general, OC female.
No, which entry?
The very top column. That's.
For example,
Yes.
OMC Hyderabad. What OMC HYD means? OMC Hyderabad.
Lordship,
What is OMC HYD?
my lord, Usmania Medical.
Swami's Medical College.
Ah.
The subject, if your lordship see,
KMC,
is
Gandhi Medical College. My lord, KMC.
KMC Kakatiya Medical, then is Government
Yeah.
Medical College Nizamabad.
You are referring to only entry one, right? This first.
No, I'm asking your lordship to look at the vertical, not no, look at the horizontal, not the vertical.
First column is serial number, my lord.
So,
Second column is name of the college. My lord, third column is
Okay.
local and
First,
non-local.
we want to refer to which this thing, which.
I want your lordships to go to above number 1 is a whole set of columns on the horizontal. The horizontal line, the first horizontal line,
Yes.
which says college serial number dash, and then it says OCG, OCF, OCP, HG.
So which entry?
No. It says OC means open category general.
Ah.
The number of seats are given below against each college. Similarly, OC, that is open category female candidates, against each college, the number of seats are given. Then it says OC
You
is the
fit in which category? Here.
My complaint is I am not categorized.
So that is the writ petition above. We are deciding your IA.
Yes,
So
I'm showing your lordships
Ah.
that if you do not categorize me, I will have no chance of getting any admission. In fact, my lords, if your lordship see the second column, open category female, did it come up?
So this is that we have understood that there is this is your grievance in the writ petition that there is no despite interim orders they have not provided
Not provided?
this thing and that's why they are in contempt proceedings have
Yes, they are.
been initiated against them.
So my point is
So
that
like this for the purposes of granting admission to gynecology, this may not be relevant.
no, only to show your lordships,
No provision has been made.
no provision has been made. And that in the absence of a provision, the argument of merit simpliciter is no argument, because if you go to merit simpliciter, open category women wouldn't have got seat, open category physically handicapped would not have got seat. Open category women physically handicapped, the other categories, none of them would have got seats. So to now, our SC would not have got a seat, ST would not have got a seat, only merit would have gone by. You have decided, I know, that an equal game playing field will have to be created, as a consequence of which reservations are provided. How do you work the reservation? You work out the reservation by creating a matrix. In the matrix, you say
You are the only eligible candidate, right?
there is one more person who's eligible, whose writ petition your lordships heard yesterday.
Yes.
There are only
You are more meritorious.
there are only two transgender
No, no,
candidates.
no. So you are amongst the two, you are more meritorious.
I'm more meritorious than the other person. Yes.
So therefore, I mean, therefore your case is that you are the only person most meritorious. Therefore, you should be given admission in a seat as per your choice.
Yes. That's the
And this is your choice
that is my,
that they should, right?
that's right. That's my point. That's my point.
Okay. And what is the prayer? Please read for our sake. Page 9. In accordance with web options and compliance of the order in a manner beneficial. The orders are already there. If
Yes.
they have not complied with, they are facing contempt. We cannot issue another perhaps direction.
Well, this is a matter of abundant caution. So I'm only erring on the side of caution. And the reason why I filed this application is to ensure they don't say tomorrow that you have not specifically sought a direction of this nature, more beneficial. In gynecology, there were other candidates. That is why I filed this application, because my specific preference number 1 was gynecology, and I was willing to take a seat.
That you should amend the prayer in the petition, that main petition instead of IA. In the main petition also you should pray that I want admission in MA gynecology, whatever, MS gynecology. See.
My lordship, may I just say two things?
That seems we will do the more they will be. They see the causes that they will be. It's vacation should be actually. To read this argument to subject. Sometime. So how many seats in MS gynecology are vacant according to you?
If at the mop-up, my lords, I don't think they've notified the total number of vacancies in the mop-up.
No, but we can, I mean, by way of, you are asking us to admit you in MS gynecology course by way of an interim order.
I'll just let you.
That can happen only if the post is vacant. So any seats are vacant.
I'll let your lordships know in a couple of minutes.
Yes.
Thanks. My lords, I'm told that the data available in the public domain does not
there.
mention.
We'll ask him.
There are no seats, Milord.
No seats.
No seats are available in mop round the council.
No seats in mop-up round.
Mop round of gynecology subject. Other seats are there.
No, but she wants only in gynecology. You will have to expel one candidate, cancel admission and give. That's the what prayer is. Yes. Yes, Mr. Rao.
That is.
Yes, Mr. Rao, please.
That is not possible, Milord, unless.
No, not just lighter vein, I said. Yes. We're not saying you argue your case on merit.
My submission lordship.
I must tell your lordships.
Milord, they.
As a bar, my lords, we often don't understand the lighter humor that comes from
Ah, that's what.
we take ourselves very seriously.
Milord, my commission lordship says.
Yes.
Milord, lordship, kindly, Milord, Milord, lordship has already seen, Milord. I want to take your lordship, so this is
Before that,
judgment.
I just have a couple of things and then.
All right. Please tell. Yes.
Well, my main problem is this. It's a decade since Nalsa judgment came. I came before this court well before the counselling began. The state government and the central government, the two of whom were required under Nalsa to take steps, have chosen not only to keep quiet, but have also chosen to not file a counter even in this writ petition till today. In the writ petition, none of them have filed counters. While they proceed with the admissions for yet another academic year for something as precious as medical college seats. What happens? This court steps in. This court steps in to sensitize the institution and tell them, listen, we are moving from the old paradigm. Please ensure that this person gets a preferential seat somewhere or the other. Typically, and not surprisingly, the response is, the university says government has not done it, government says medical council hasn't done it, medical council says government has not done it. I ran from pillar to post. I've come back to this court and said, please reserve a seat for me in a subject of my choice. This court passed an order saying, consider the person under the two categories separately for whichever is more favorable to them, which would entitle them to consider the person in the category of a transgender separately. They have not done so. Now the argument.
So that's why contempt, they will be punished if they have not done.
My lords, while my lords, I know your lordships would punish them. That would, at the end of the day, be a poor consequence
No,
for
no.
somebody.
This thing, one we are still trying to understand how this thing, what is the basis of claiming admission in gynecology department only? How you are entitled?
My lords, I am
How-
told in Gandhi and in OC female and in OC general, one seat is still lying vacant. Each. In gynecology. But this is what I am told by instructions, my lords. It's subject to verification by the other side. Local OC female one and OC general one are. May I suggest one thing, my lords? Let Mr. Prabhakar check and come back to the court after an hour or after lunch so that some order can be passed.
All right, 2:30.
I will also find out from her if she has it. May I take one more liberty with your lordships? May I take a liberty, please? In my application, I've asked for gynecology. May I ask my client if there is some other subject, share that information with him so that he can come back and say, not that, but this is available.
All right.
Problem.
Find out.
Problem.
Yes, 2:30.
In this matter, I am appearing for respondent. I'm filing counter today, my lord. I served it.
You are filing.
Yes, I served it on
Valid
the other
counsel
side.
for respondent submits that the copy of counter shall be filed during the course of the day.
Yes.
Learned counsel for the petitioners may go through the same and may file reply within a period of 3 weeks if so advised.
My lords, with permission, I'm appearing for petitioners, my lord. My lord, we have filed this writ petition challenging the rights of Act 26 of 2017 passed by the Telangana government, my lords, which has been decided in favor of the SSC in the case of Sri Sri Engineering Works, my lord.
Where is that order?
My lords, copy of order is attached in writ petition book from page number 172 to 216.
170.
My lord, after this, there were some around 30 batch matters were decided under this case, my lord. After this, there were 60
Who
other matters,
appears?
my lords.
Who appears for respondents?
GP for commercial taxes, my lords.
You have not supplied a copy.
We have
to them.
supplied the copy, my lords.
All right.
My lord, in Sri Sri
Mr.
Engineering,
GP for commercial tax.
Not informed.
Inform means what? In cases where private respondents are there, they appear and seek time. Even before counsel for appellant is can argue, address us on admission. This case,
I apologize.
you are saying that we will inform. We are not dependent on information, right? If
But
he doesn't
that is
appear, he
past-
will face consequences. What is
Request
it?
for passover.
Oh, nothing. No. Why should it be passed? It's covered in this petition, comma, the petitioner inter alia has assailed the validity of
But this is infructuous, my lord.
Infructuous.
The not date is 30th September, my lord, for admission into MBBS course.
Hmm?
Petitioner studied, my lord, in Andhra area.
Ah. Let him argue. Yes.
Lord, I have filed a writ petition earlier. Your lordships have passed orders directing them to consider my representation. Lord, kindly see the
So it has been rejected on the ground that you are not a local candidate. You want us to give you a certificate that you are a local candidate.
It is not rejected on the ground that I am not a local candidate.
Ah.
It is rejected on the ground. Kindly see page 10.
Whatever ground, it has been rejected.
On the ground that the presidential order applies, Lord, your lordship judgment specifically says that it is not, presidential order does not apply.
All right.
Lord, kindly see page 10.
Whatever, Mister, if they pass erroneous order, that doesn't mean that we will grant you local certificate and admit you.
Lordship, kindly see. I have
This
produced a
is
local
Mr.
certificate for them.
1 minute. We are telling you the crux of the matter. The crux is that 1 to 10th you have studied in Kurnool probably, which is in Andhra Pradesh, not in Telangana, right? Intermediate in Krishna district, which is again Andhra.
Yes.
Under rules, you are not a local, you cannot be treated as local candidate. This is the position. And in our division bench judgment only, also we have held that the petitioners who have studied beyond this thing, not complied, they are not, their cases doesn't fall under rule 4. They may say anything. They may say sky is red. So therefore we cannot quash the order and grant you admission. They can say.
Your lordship judgment earlier says that if they produce a residence certificate of Telangana, they have to be considered as local candidates.
Yes.
I have produced a local certificate. They have not considered my local certificate. They simply say that I do not fall within the four corners of presidential order. Your lordship judgment is that presidential order does not apply to these admissions.
So you are challenging what? Page 10.
The page 10 rejection order.
Yes. What ground?
But the ground is
That you are a local candidate.
No. That the division bench order passed by your lordships says that the presidential order does not apply to these admissions.
In which paragraph?
Kindly see answer to issue number 1.
Hmm.
Yeah. Page 39, page 108, internal page 39 of the order of your lordships.
13.
Paragraph 54.
Yes.
Thus, from perusal of paragraph number 3 of COMS number 114, it is evident that 2000 rules have neither been framed in exercise of powers under Article 320 of the Constitution of India nor under the presidential order. Therefore, the issue number 1 is answered in the negative by stating that 2017 rules have neither been framed under Article 371D of the Constitution of India nor under the presidential.
What was the issue? Issue was whether it have been framed under presidential order.
Yes. Now, when there is no president, the rules are not framed under the presidential order, and your lordships have directed my representation to be considered in the light of the division bench judgment. This judgment, the consideration is not proper. They could not have rejected my representation on the ground that I do not fall within the corners of the presidential order. That is my submission. And your lordship judgment is very clear. If they produce a residence certificate, they have to be considered as local.
No, they means the petitioners in that case. You were there.
I am entitled to similar treatment.
No. That we have also taken a view. That the person who approached belatedly are not entitled to similar view.
I have not approached belatedly. Your lordship kindly see. Within time I have approached. Maybe.
No. You are saying you are entitled to similar treatment. That is, that issue we have dealt with by reasoned order. That may be according to you wrong, but it binds us.
I am not saying that. I am not saying that.
No, we have taken a view that the persons who have filed writ petitions after 25 days after decision in this, they are not entitled to claim the benefit of judgment. We have held so.
Already, my case.
We know what happened.
I understand.
It may be wrong.
I understand what your lordship. In my case, your lordships have passed an order on 5/9/2023. Immediately on 6/9/2023, I have made a representation to the second respondent.
Merely because we issue a direction to consider representation, that doesn't mean that you are entitled to admission.
Good. I am not saying that I am entitled to admission only because your lordships have given a direction. Because whether I am entitled to or not, your lordship will decide. Because I have produced a local certificate.
Yes.
And then the counseling was going on up to 12/9. Your lordships are directed consideration.
No, we are only trying to meet your submission that since you have produced a local certificate, therefore you are entitled to admission. This is what your
My
submission.
local certificate is not at all considered.
All right.
The lordship will kindly see on on 5/9, I have this honorable.
No, we are directing against inquiry against the concerned Tehsildar, and which is saying that it is obviously it has been managed, and in any case you are not entitled. That we will deal with it. Mr. D, you take action. This is what they are on the own showing. The candidate has studied in Kurnool and Krishna district, and your Tehsildar is saying that 18 years.
That is the father's residence. Sir.
Yeah.
The father is an employee of the government employee of Telangana state.
But that doesn't mean that candidate becomes a local employee. If he is studying in Jammu and Kashmir, that doesn't mean that father is a study of a student or like the employee of government of Telangana.
A person can be permanent resident of a particular place,
Yes.
but educated somewhere else.
Fine.
That is the import of the certificate granted by the Tehsildar.
All
The petitioner is a local candidate of Andhra Pradesh, not Telangana. He studied from 1 to
no, but both Andhra also, Telangana also local cat, because Tehsildar decides that it should be like this. What is this? That's why. Oh, you are feeling relieved, right? That Tehsildar is saved from the action. Yes. No, but where is petitioner certificate? No certificate.
Petitioner residence certificate is at page 25.
25. Page 20. Same. Yes, 25.
But this is wrong.
Wrong means, mister, you are telling us we will record this. I mean, it's not a place where you can say anything and get away. We will say this, that the government advocate himself said that this is wrong. This is what is like managing things, right? She is not residing here. He is giving a certificate. It's all like playing fraud on the system. It's not the petitioner's case that she has resided and he is giving certificate. How can she stay here and pass examination from Kurnool and Krishna district? She was online from class 1. Huh? Then? All right.
I will only say one sentence and leave it. A person can be a permanent resident of this state.
Yeah, this all is
educated elsewhere. That much your lordship kindly consider.
Huh?
That argument your lordship kindly consider.
What?
A person can be a permanent resident of Telangana. She is a native of Telangana. Her father or grandfather, everyone is residents of Telangana.
No, but have you not prosecuted your studies from Kurnool?
Yes, that is so. I have stated in my.
You are saying that domicile is this all has been dealt with. Mr. Domicile is something different. Domicile is a permanent this thing. This not we are not the authority to decide here. Right. Your challenge is only confined to this order.
Yes.
29. Yes. Mark the presence. The petitioner is an aspirant for MBBS stroke. Petitioner who is an See, Mr. This is, we told you, and Advocate General had assured us that he will issue instructions to Tehsildar. What, like, just like this, they are issuing, like, I mean, obviously for extraneous consideration, which we can't speak from here. You understand, right? How the administration is being run, that's classic example.
Yes.
This is what it is, despite information, if this is being done, so what would have been? Yes. 22.
May I please, Your Lords? Petitioner appeared.
So Mr. Rao, this case we really want to understand. I mean, he has no idea about the case. Like, so from the way, why we are saying no idea without hearing him is because the way the petition has been drafted, he has not understood the case himself, so he can't assist us. The grievance appears to be that he has appeared in NEET PG examination and opted on 27/9/2023 for MD radio diagnostic seat. And
All India quota, under All India quota.
All India quota.
University.
So then, even though he is eligible, he is not. You see what the government is. What can you make of it? We really don't know. We have tried to go through it, but we are unable to. What he himself is, he can't. We are sure that he cannot himself make out what is it. 1 minute. 1 minute. We will hear you, Mister. But we must understand the case before dismissing it, right? You are unable to explain also what can be done. See, locked, read para 3, what does it mean? Para 3 of the petition. Availed of choices for round 3 by giving option for MD or same was locked as per locking status. And as per data available, then.
But there was a mistake, my lord, in it. First, may kindly say para 1, my lord. Para 1, lord, page 8. I said I am filing the laboratories and being not considering. And HIGHCOURT choices in allotment of PG in MD is a
Locked.
non-resident Indian quota, NRI quota, having given choice the order of preference to the second respondent.
So he has given under what quota? NRI quota. NRI quota.
NRI quota.
So for which discipline? MD?
MD radiology. Radiodiagnostics.
So what mistake has been committed?
Then Lords may kindly see, my lord. The third directly intimate discrepancy in the result to email. Then Lords may kindly see with the need PG rank so and so All India quota. An intimation by letter dated 27/9/2023 that provisional result for round 3 directly to intimate any discrepancy in the result MCC count through email.
No. So what is, see, he is, 1 minute, he has participated in NEET PG and NRI candidate applied for MD radio diagnostics on 27/9.
That's right.
So what is happened thereafter? Not being allotted the seat.
Then the seat was not allotted. But in the notification, the result notification, there was a provision to make the grievance of the queries. He appears to have submitted the grievance, but results is not received.
No. This what we have understood is participated in NEET PG, no problem. All in NRI candidate, no problem. Applied for, they opted for MD radio diagnostics on 27/9/23, no problem. What is the problem? That what we are unable to make it from the petition. Can you tell us?
Yes,
now?
Yes, Millard.
What happened after 27/9?
Millard, they had given a notice if the provisional selection was, the list was published, and they asked us to, if any discrepancy is there in the provisional list, we point out, Millard. And she has pointed out by giving an email that she has given the options, and without considering the options, they say that no options were given.
Where is
page 15, as page 15, Millard. Page 15, they say that no choices were given by the petitioner.
Showing 0?
Yes, at page 15, Millard. After going through this, Millard, the provisional list.
No. Where is that? No choice is given.
Filled choices 0 in the yellow color column, Millard.
No, there is no yellow. It's this thing. This black and white. No yellow color.
Page 15, Millard.
You have kept.
Second one.
You have kept yellow color for yourself.
No, Millard, I will. There is another.
There is no yellow.
Second, Millard. Total available choices, filled choices.
Can you see, Millard, there are four tables, Millard. One is total available choices, 4,164. There will be all chose 0. Unfilled choices.
That's what he's saying that even
Unfilled choices, Millard, he did not even, Millard.
That's what he's saying. 27.9
Yes.
filled. Where is that? Where is that filled thing?
Page 16, Millard. Their own website says that locked choices.
No. What is the document to show that you filled choices?
This is this page
16.
Yes, Millard. It is from their website. Locking status choice locked by candidate.
Where are you reading?
Yes, Millard. In the bottom of the page, Millard. Locked.
Mr. Locked something.
Status choice locked by candidate on 27/9/2023 at 6:15 a.m.
So,
And this was pointed out, Millard, by way of email in persons of the notice that was issued at page 13, Millard. And in spite of, Millard, though the provisional list is not a final one, they asked for the discrepancies. If it is there, Millard, it was pointed out.
yes, Mr. Rao. This page.
They have to verify those. MCC has to verify, Medical Counseling Committee has to verify and report back.
You are
And the All India quota, Millard, they are nothing.
not appearing. Yes, madam. No, that's fine, madam. We are asking about controversy, not who is appearing for whom. That is not, that stage is over.
Extensions, Your Lordship, kind of logging her options. Why it was not accepted, I need to receive her instructions, Your Lordship. I have already forwarded the papers, Your Lordship. May I accommodate?
Arey, Mr. Praveen, you see, Mr.
That's where kindly tomorrow.
You look into it. We are not sure whether. Learned counsel for the petitioner submits that the petitioner had appeared in NEET PG notice to R2.
I permitted to take out.
Whatever.
College is nothing to do. It's only allotment. Then only they have to join. College is nothing.
Notice to R2. Yes.
Counter file below. Counter file below.
Yes.
I'm an unofficial respondent 88.
Counter on behalf of 2, 4 and 5 to be
Yes,
filed.
24575.
So, none for the petitioner. Counters on behalf of respondents have been filed. Let reply if any on behalf of petitioners be filed within 3 weeks list thereafter.
Yesterday, Minada, the 6-7 April 1988,
I proceeded the
proceedings not drafted.
Order past tense.
Lord, I prepared the synopsis along with all the orders, original orders also.
Now you have understood, right?
All the officials, they are also present.
All right. So her work is lighter.
Because of my lord's advice, Lord, yesterday we went all the even laws.
Get it.
May some.
No, what is it? So where is 6-7 April 88?
Just now, not having.
You are given?
Yes. Oh.
Page 1. But I bring to the notice of my lords only 3 dates, Lord. The additional papers which are before my lord, Lord, the writ petition was filed in 1992. Lord, the disposed in 2006, Lord, the 4th, 5th, Lord, the April 2006 writ petition is disposed, Lord. Challenging the same, Lord, we filed the writ appeal in 2006. Lord, the NTPC filed in 2010. After 4 years of the Lord, the orders of the Lord, the writ orders, they filed in 2010. Lord, now the additional papers in which are before my lord, last Lord, the proceedings, document number 2, Lord, document number 2 is addressed in 2010 by the Forest Department, requesting the NTPC to pay the afforestation amount. Lord, the confirming the same, Lord, the document number 3. Before my lord, they agree that the 590 acres is already identified. Please confirm for your approval.
Mr. Your defense is simple. You have only complied with the instructions of central government.
Yes.
Insofar as afforestation is concerned.
Yes.
And the second submission perhaps is which you are not arguing is that under Rule 6 they have the authority to impose that condition.
Yes.
So refer to that rule, no? What document and this thing? 4 years. The fact remains it has been entertained. So it is filed after 4 years or 8 years doesn't make any difference.
Yes.
Right? Yes. It has been entertained. The petition has been decided on merits.
Yes,
not challenged on the ground that it is filed after 4 years.
Yes.
Whether single judge has dismissed on the ground that filed after writ appeal. Which rule? The central government has power.
Rule 1981, Lord.
Yes.
Rule 3, constitution of the advisory committee, Lord.
The conduct of business of the committee.
Yes, Lord. Rule 3 is the, Lord, the under the rule.
So you are referring to forest conservation rules?
Yes.
What is superseded?
Lord, this is superseded by the amendments, Lord. Certain amendments were brought in 2002. And also now in 2022 also certain other amendments. Lord, as far as this case is concerned, only 1981 rules, Lord, they will apply. Lord, the reservation was allowed by the central government by virtue of these rules, Lord.
Which rule?
Rule 5, Lord. Rule 5.2, Lord. May I permit to read? The committee shall have due regard to all of or any of the following matters while tendering its advice on the proposals referred in the Rule 1. Lord, the rule, Lord, the D. Lord, whether the rule D, Lord, 5.2 D, Lord, whether the state government or the other authority undertakes to provide its cost for acquisition of the land or an equivalent area and afforestation thereof. While tendering the advice, the committee may also suggest any conditions or restrictions. Then the rule 6, action of the central government on the advice of the committee. The central government shall, after considering the advice of the committee tendered under rule 5, and after such further inquiry as it may consider necessary, grant approval to the proposal with or without condition or reject the same. So under these rules, the central government issued the proceedings, the referred in GO 172, as item reference number 5. By virtue of this powers, the state government issued the GO, duly requesting the NTPC, which is the user agency, to pay the compensatory amounts. That is admittedly agreed by them, despite of the filing the writ appeal.
Agreed?
Agreed, Lord.
What agreed?
They admitted that we are ready to, Lord, allocate the open land as well as ready to pay the compensatory amounts, Lord.
Perhaps the case of the petitioner is that the Forest Conservation Act came into force on 27/12/80.
Yes, Lord.
And before that the land was transferred, therefore the act does not apply.
Lord. 127, Lord, the GO clearly demonstrates that though the government represented by the Department of the Revenue issued the memos in a tentative way to be allocated, Lord. The wording used in the GO is to be allocated on a condition of the payment of the 1 lakh into one extent 100, 115 and another extent 6 lakhs 590 acres. Lord, they are not aware that the reserve forest is coming in those lands.
No, Mr. What the though it has not been argued, the contention of NTPC may be. This is our predicament that we have to formulate the submission on behalf of the appellant also. It has not been argued, but what they will argue is that Forest Conservation Act came into force on 27/12/80.
Yes.
Before that it was allotted.
This was to under the
13/12, 1979 and 3/4/80. Therefore, all this you cannot, provisions of the act you cannot apply.
Yes.
This probably, we don't know whether they will argue or not.
Is their contention even in the writ petition also? My answer is that, Lord, by virtue of the two GOs, which is, Lord, the 12th December 1979, one extent is transferred.
31st December.
31st December. Another is the 3rd April 1980. These two GOs doesn't refer with the reserve forest. They are under impression that it's a revenue lands. There is no reference. Lord, the illegal, the mistake was corrected by passing the another GO after taking the consent from the central government.
When?
That is the 6th or 7th April 1988.
How did you know that it's this thing? How did you know that it's this thing, forest land?
Not it is a reserve forest, not the notified forest in the year 1965 itself.
So then why did you allot it, treating it?
We have not let the revenue department tentatively not agreed to allocate not. What the
Where is the order? You give Mr.
Refer not the page
31/12/79.
That can be find in my 708. 708.
Notification, they cannot pass any notice. Deleting the exams to the result, they will be available for delineation.
My lord, I take my lord's page number 33 of my writ appeal bundle.
33.
My lord, this is the GO 1926, my lord,
Yes.
issued by the Revenue Department, my lord, the date 31st December 1979. The abstract itself, my lord, the alienation of the land, Karimnagar district, Peddapalli Taluk, Mughal Pahad village, survey number 1, 2, 13, 14, 22, extent of 115.
No, so there, it's correct, right? So there subsequently you have to point out that how, when you discovered that it's a forest
Yes.
land and what action have
Yes.
you taken?
I mean,
One is
Lord,
31, 1 minute, 31, where is 3/4/1980?
1980, my lord, page number 39, my lord.
Page
Page number 39, my lord. GO 172.
37.
Yes, 39, man.
The 3rd April 1980, right?
3rd April is the another GO. Subsequent 39.
39 is 25/5/8.
Yes, 25/5, 1988.
88. We are about 3rd of April 1980. It is at page 37.
37, my lord.
So when did you learn that this is a forest land, and then as you are saying?
Yes, ma'am.
When?
Lord, by virtue of these two GOs, Lord, the NTPC under impression that it is entire land, including the reserve forest, which is adjacent to their land, revenue land, which is allocated in the two GOs, they attempted to enter into my land, the forest lands. Then the forest people,
Did you file counter in the writ petition?
filed it.
Where is that counter? What is the stand taken? This all, I mean, you cannot say like a story. You have to plead it, right?
Yes.
Where is that defense? Tell us. You want this? Yes, we want this.
Counter, it appears that the counter is not accepted.
So have you taken a stand like this? You cannot tell a story at this stage.
No, my lord, 3 cases were registered against the NTPC. Lord, saying that you interfered into our property. That's under three proceedings.
Where is this demand
Counter is there,
notice?
Demand notice, Lord, that can
Counter
be
of
filed.
second petition. Counter of the third.
Which WS 708?
Yes, not second April.
You can give your copy, Mr. Please.
927, page number 116.
Array, Mr. You don't even know what is your counter. Where, madam? Page?
116.
Page?
116.
There is a writ appeal 708.
927.
Page 11.
927. Writ appeal 927.
Page 92.
Writ appeal 927.
Counter
Page number
number 3.
11. Yes. Counter by respond number 3. Para 3. That is your defense, Mr. in para 3.
My apologies.
That subsequently we learned that it's a forest land.
Yes.
That's what we are.
But then the demand notice was raised, my lord, repeatedly.
Fine.
Not the
Got it. So what is your submission?
page number 42 is my.
Mr. You have imposed the condition in pursuance of the condition imposed by central government. Central government has power under Rule 6 of Forest Conservation Rules. Why? How do you meet the contention of the petitioner that the Forest Conservation Act does not apply? Because land was handed over to us before commencement of the act. That is probably the argument. We don't know what she will argue, but
My humble submission, my lord, once, my lord, the constituted any reserve forest as a reserve forest, my lord, unless until there is a proceedings, my lord, it cannot be handed over. The mere passing of the GO, that to be very, it itself speaks that the to be or terminated, my lord, the wording used, then the my lord, land virtually in the field, my lord, it is not unreserved either delivered. So, my lord, the forest department is not the implementing, working under the special statute. Not the statute itself, not the that permit not the any alienation of the reserve forest unless until there is a procedure. Not. My humble submission will not the mere passing of the GOs, not the 1979 and 80, not the April, not the will not the take away my position and my rights and not the statutory protection not available to the forest lands. Not. I may be permitted to invite that. Page number 5 of my additional papers. Page number 4. Just now I placed before my lord.
No relate tangible. Okay. Yes.
Now I invite page number 4 of my additional material paper. Just now I placed before my lord. In these proceedings, my lord, the NTPC clearly admits that I am permitted to read, my lord, if my lord. Page number 4. Lord, it is addressed by the Lord, the Shafi IFS officer to the Lord. Please refer to your letter so and so 2010 received NTPC Ramagundam also, where it was requested to hand over an area of the 304 hectares of non-forest land within 7 days from the receipt of your letter by the NTPC Ramagundam. In this regard, we would like to state that the state government of Andhra Pradesh, represented by the Secretary Forest Department and others, had filed the writ appeal number 70.
There is nothing right in this. We have read it. What? So, state appeal is filed pending and matter is sub judice. Please do not take any action.
Following the page number 5. Permitted to read, Mr.
No. Do you mean to say that the earlier area which was transferred was different and this is different?
Definitely.
Huh?
Yes, Milord. The land claimed by the forest department is only 360 acres. 380 acres. But the lands transferred under the 2 GOs is 1 GO 115, and the another GO 690 acres. 690 acres.
And this is 380 is different.
Yes, my lord.
What survey number?
My lord, the first is 590, my lord. So now my humble submission is that they are not aware that the reserve forest is included. This is the additional, my lord, the additional land.
1 minute, mister. You are not even prepared to tell us survey number that we have to note. Different survey number, right?
Yes, ma'am. $453.
1 minute. And 380 acres is what this is?
Lord, the land.
This is 152 hectares. This is of survey number which land? 152 hectares of diversion which you have permitted. 25/5/1988. This is of which survey number?
453, 479,
453,
479, 483. Kundanpalli.
No, these survey numbers are there, mister. 453, 479, 483 is included in 1690 acres. The previous one. It is 690, it's not 690, 590. What you say, anything like this is 590, mister. No, I have wrote it down. The 115 acres is half, 13, 14, 22. 590 is 360, 369, 431, 453, 479, 483, 486, 465, so and so. We are trying only to meet the submission that they are possible. Submission will not handle.
590 is only 2 survey numbers.
So where is the order of this allotment after this? Market value, etc. See, mister, an order, you understand, right? No, don't. Like, why we are asking you question is in order to deal with the question of applicability of Forest Conservation Act. Their argument is that these lands have been allotted prior to commencement of the Forest Conservation Act. Therefore, Forest Conservation Act cannot be made applicable. So, these orders of allotment have been made subject to payment of that 1,16,000 whatever amount when that was paid, when the formalities were complied with. Because is it after or before or after the act?
Lord, I just say, Lord.
How do you meet the submission that the lands were allotted on 31/12/1979, 3/4/1980, whereas Forest Conservation Act has come into force on 27/12/1980?
My answer
Since prior to this thing, it was already transferred.
Lord, my answer is that, Lord, in the first GO, the GOs in which we are holding the properties are not affected. In the two GOs, not the, I can clear. In first GO, 115 acres was transferred, that is pertains to the survey number 1 by 2, 13, 14 and 22. But whereas the 590 acres is concerned, under the
I have noted down, Mr.
360 and Lord the 369. Now the Lord the relaxation.
No, there are several other 360, 369, 431. All this you read, Mr.
Yes, now
there are several survey numbers. So page 37, you read fourth line. 590 acres in survey number
360, 369, 431, 453, 479, 483, 486, 465, 469, 472, 484 and 378.
So this 453, right?
Yes.
453, 479 and 483. It is included in this 152 hectares is of 453, 479, 483. So numbers are the same.
Yes.
So then how do you say? Then
I beg Lord, one more Lord the observations, Lord. The same page 37, Lord. Fourth line, Lord. So and so survey numbers, Karimnagar districts be alienated in favor of the National Thermal Power Corporation Limited, Ramagundam, for construction of the ash pond.
Yes.
So, Lord, the real transfer is not happened, Lord. The even otherwise also Revenue Department is not competent to deal with the lands which are under the Telangana Forest Act 1967. Lord.
Where is the notification saying that these lands are forest lands, reserved forest, whatever?
That papers are not, yes, Lord, not included, Lord. This is long back file, Lord. It's my.
No.
However, even otherwise, Lord, I may, Lord, say they are not on the Lord on the point that this is not unreserved, Lord. It's not a forest land. Lord, partly the two DOs, partly revenue land is transferred. Lord, without.
Where is the amendment to the rate petition? Yesterday we saw. Amendment to the rate petition.
Page number 143. Page number 140.
This one. Page. Not there. Something else. No, this paper book is different. This. You have the amendment, right?
Yes.
See the grounds on which it is challenged. We don't know where from the guidelines 3.2.1. Where is guideline 3.2.1? See the prayer at page 127, Mister. This book will be 73. 3.2.1. Where is 3.73? Application of forest 3.2. Three point two point one. Where is 3.2.4.3? So read the prayer in the amendment petition.
For the reasons mentioned herein, the writ petition it is submitted that the Honorable High Court may be pleased to allow the writ petition restraining the respondents from claiming compensatory afforestation twice to the non-forest area and also 1500 per hectare towards afforestation. Void government order 7th April 88 and the communicated void GOMS number 172 25th May 1988.
By receiving land, read further. You have stopped. By receiving land for compulsory afforestation as per 3.2.1 guideline. Mr. Yes, where is this 3.2.1 guideline? They are not saying that they are liable. They are liable for compensatory afforestation that they are admitting.
Yes.
But this is they want as per clause 3.2.1.
Yes.
Where is that?
Page number 87 guidelines of the writ appeal. Lord,
You
Right.
have a different this thing,
Right.
Mr. File.
927. appeal.
Huh?
It appeal 927, Mirror.
927.
Yes, second writ appeal. Because in this writ appeal, I am not a party. In second writ appeal, I am the party.
Yeah. Which this thing, this page, this paper book?
Yes, sir.
Ah,
Right.
which page?
Mirror, page number 80.
73.
Yes, Mirror. 73 it starts, Mirror.
Ah.
Page number 85, Mirror. Application of the Forest Conservation Act 1980.
Oh, just 1 minute. Page?
Page 85, Mirror. Not page class 3, not 2. Application of the Forest Conservation Act 1980.
No, they are saying class 3.2.1. Where is that? It's not there.
Next, Mirror, page 87 also, Mirror, another guidelines dated 23 June 1989.
Ah.
Guidelines for diversion of forest lands, non-forest lands. Where, Mirror, the application for page number 90, the class 3 starts.
Ah. No, there is a, like you see the prayer clause 3.2.1 we are not getting.
Yes, that one. But not here, not page
No,
number
did you, one minute, Mr. Have you got the amendment? Amendment to the petition. See, they file a petition. Madam, very good. You file a writ appeal. We bother our head out what is your case. What, madam? See, Mr. Praveen, well, this amendment. Where is afforestation rules? Huh? No, this is what forest conservation rules. So where from have you got, madam, 3.2.1 of guideline? So if it is a rule, how it can be a guideline?
That was the reason you allowed the learned thing, you can say the guidelines are not applicable because the government has no authority or power. So far as the.
No, under which rule, which provision these rules have been framed?
Because all of them are under the. The second thing, one submission is not, when they issued us, the state government revenue land,
See.
not parks land.
Guidelines on Forest Conservation Act. Who has issued these guidelines? No, who has issued these guidelines?
The Government of India and the Ministry of Environment and Forest only.
No, do you see what she is showing us?
Yes.
This man. No, but who has framed it? What is clarification? No, who has framed it? Like these rules have been made by central government, right? Who has framed these guidelines? So, Mr. The case is like this. You from the prayer clause. This should apply according to the petitioner. The petitioner is aggrieved by only this condition.
3.2.
Land for compensatory afforestation. It should be in accordance with 3.2.1. Okay. Give it to them. You see, Mr. Government Advocate, see this. Mr. Praveen Kumar, see 3.2.1. This is the point. That it should be what the condition is. It should be as per 3.2.1 of the guideline. See, Mr. So they are challenging the government order to that extent. 3.2.1.
Lord, may I put a question to myself, Lord?
1 minute. With great difficulty, after 2 days, we have understood what is the point, right? And then again, you are putting a question to yourself. That means you don't want us to decide. See how beautiful this tiger is. This book. A tiger. Do we have tigers in the state of Telangana? No.
We have the tigers.
Tigers.
It was notified.
Got it, Mr.
I don't.
So this is the condition number 7. Twice the non-forest area. That is what is challenged. It should be equal to.
Yes.
No, but these guidelines will not apply. See, guidelines because rule will prevail. What guideline? Implementation. No. This rule will prevail. What the guideline? Let there be a forest cover. Why we should interfere and reduce the forest cover?
But with due respect, no finding with regard to the government and the judgment.
Mr. Praveen Kumar, see our predicament. It has taken us 2 days to understand what is the point. You file a writ appeal, let judges scratch their head and find out what is the point, because we have taken out to do justice. She will only file SLP if it is decided against her.
That's
the
taken a lot of
predicament.
pain.
You have seen what she has argued since yesterday. Yes, madam, anything else to say now?
Sorry, Your Lordship,
Ah,
some different sort of opinion. It is not that.
no, please argue whatever you want.
My issue is
This is NTPC, madam.
I do remember you.
You are not arguing anything. The NTPC will not take a ground before Supreme Court that council did not argue.
It is not that, Your Lordship. Both the GOs.
What is?
Both the GOs are passed.
Challenge.
3.3.
What is under challenge according to you?
I have challenged the 172 GO, Your Lordship, with regard to afforestation, 1:2 ratio, compensation we will not pay. And what actually happened is this confusion arose because the central government and state government, as well as the NTPC official also are corresponding without knowing the legality of the issue. One. Secondly,
Who has framed the guidelines, madam, which you have passed over?
my submission is this, Your Lordship. So far as the two
No, you have referred to the guidelines, right? Who has framed it?
the central government only framed.
Where is that? Where is that? We don't get it that central government has framed.
I gave it to page number.
You see, read it from where it says that central government has framed. And under rule.
As it is in the book, Your Lordship, we collected it because they were corresponding with us. Because my officials have done that. Secondly, Your Lordship, those two GOs are there in 79 to 80, prior to the new act came into force. When under central government is not put the facts properly, Your Lordship, all those areas given in the survey numbers are of revenue land as per the state government of Andhra Pradesh. That's why the state government has handed over to us and we paid the money to state government. When we are arguing the writ petition, we pointed out already we paid the money to you. If there is any payment, you both settle. That they have not replied to. They were silent about that. And nowhere they have identified saying that this particular area is the result farms. And in all the GOs, Your Lordship, particularly, now I got a message that in 1969 also.
Madam, in the impugned GO 25/5/1988, nowhere amount has been demanded from you.
Yeah.
Permission for diversion of the land has been granted.
Yeah.
And you are challenging that order only. That means you don't want diversion of land. Right?
That is true.
That is true.
That is
The order is in your favor. You are challenging it, right?
not that.
We don't.
What actually happened is.
Nobody has demanded money from you, madam. This is utterly misconceived notion. That only shows that you have not read the file even after 2 days. There is no order in this 25/5/1988. The order nowhere directs you to pay any amount. It only permits diversion of land subject to the condition.
Actually, the instructions are the land, they cannot divert, Your Lordship, because it was only 2.4 kilometers pipeline going. They want 254 acres.
We don't know, madam. What?
Madam, in the prayer, you are asking that 15,000 per acre. Where do you get this figure from? Was there any demand? No, please follow. Was there any demand, intimation, memo, anything? In your prayer, you have.
Strange, right? 2 days. And
The question is on what basis we have to assume this 15,000 per acre. There must be some basis to that. No. Please wait. This is the prayer which is taught by you in the writ petition.
Yes.
The repeatedly this bench is asking you, where do you get these figures from? On what basis?
I'll just.
Is there any order, intimation, memo, or any proceeding to that effect, which has to be challenged?
Nothing. He doesn't know. This is second day, right? Second day. The whole burden is on the court.
It's my
See,
lord,
Mr.
page number 40.
We only advise you when if you get an opportunity in future, don't become a judge. It's the problem we are facing yesterday. Since yesterday, the life is much more easier there. See, turning pages, doing everything, not knowing what is the case about, and this is second day performance. Not that all of a sudden it is. This is second day. She knows that it will be heard today despite that.
Take page 145 in my material papers.
WA 708.
Yes.
We asked what are the arguments, right?
Page 145, Your Honor.
No, what are your submissions on?
It is ordered that the notices to issue the respondent herein to show cause why should not be complied with, and that injunction to it be issued, claiming compensatory afforestation twice non-forest land for 15,000 per acre, because in the previous writ petition 486 it has been questioned. Because of that, that order was passed, Your Lordship.
What happened to that writ petition?
That they gave a liberty to us to file the writ petition, so this writ petition was filed. This material fact was in the previous writ petition.
This is the prayer. Substitute para 18. There's nothing like. Madam, your substituted prayer is, we are sorry to tell you, you don't even know what was the prayer in the writ petition. Substituted prayer is at page 127, which you have by way of an amendment substituted.
Yes, sure.
The grievance is only with regard to afforestation. You want that it should be as per 3.2.1 of the guideline instead of 2:1. That is what is your this thing. It should be 1:1 instead of 2:1. That is the only grievance here at page 127 amendment.
Yes, Your Lordship. That is because for singularity cause.
We don't know what is because.
I
We are trying to tell you what is your case.
1:1 ratio given for NTPC. They said 1:2. That's why it has been challenged.
That's the only grievance. That is the only grievance at page 127. See the amendment made by you. You have substituted the prayer clause.
Yes.
What, madam? This is the only prayer. Substitute the following prayer. This is the prayer. They have to seek appropriately earlier. This is the this. This is the prayer. The appeal is not printed. Why this is this which tells
I sought for one. It is one in my material papers, page 158. Your Lordship,
25,588, the order in entirety is being sought without realizing that the order permits conversion. You are challenging the order dated 25/5/1988, madam, in its entirety. Imagine the consequences for NTPC if the petition is allowed. The order of conversion of land in your favor will be set aside. What, madam? You don't know what to pray for from the court. Don't know the scope of the petition. It's not that it has cropped up. Since yesterday, we are taking up this case, second day. And this is the performance. We can't, what can we say? Thank you for the assistance, your able assistance rendered to the court in deciding. There is nothing. All what to do.
The last, the only I stress last one.
Therefore, when you appear on behalf of the government, you should bear in mind the other person's case also, because she will not prepare. You will have to tell what is her case.
Lordship has not permitted me peacefully to
Please argue.
Sorry, Your Lordship.
We are required to tell you that what is the relief sought for in the petition. That shows you please argue. That's what brother is saying. We are also saying. But you are reading 145, 177. This is not argument. Please argue. And you are saying that we are not permitting, please argue whatever you want to. What are your submissions? What grounds you are challenging the order passed by learned single judge? It is a intra-court appeal.
So far as the learned single judge is concerned, Your Lordship, he gave a finding stating that so far as 1980 Act is concerned is not applicable and 1967 Act is applicable. If any permission is supposed to be taken, it will be supposed to be taken under Section 23 of the Forest Act. And at that time, when they transferred the lands by the state government, all the land is of the revenue land. It is not the forest land. Later on, the forest department has come into the picture and said this belongs to us, and it is so. That's the dispute was between the state government and the central government, whether it is a forest land or the state land. The monies were received by the.
Where is the dispute? They are not fighting. You are saying. Who is the Union of India has not filed any petition against government, and the government has not filed any petition. Where is the dispute?
The dispute is
There is no dispute. They are not. Do you have any claim against government, Mr. Ted? Then, Mr. Have you get any claim against the central government?
They mention, Your Lordship, it is not the question of dispute of money. It is a question of when the land, when work started, 3 prosecution cases were filed against our officers saying that we are trespassed into the forest land.
So central government did not say don't file cases against NTPC.
They already filed. That was the reason.
The central government did not say don't file. Where is the dispute between central government and state government?
Observe like that. I have no objection. The already pipeline was put 32 years back. If it is stopped, there will be pollution.
No, like just like because you feel like.
It is not.
This is, madam, this is the challenge to the order passed by learned single judge. You have to tell us what grounds you are challenging the order. Not like this that there you will say something, we will say.
Before Your Lordship, with regard to that, Your Lordship.
These submissions.
The findings of
why?
The findings of the learned single judge were in my favor, but lastly he dismissed it because he wrote one paragraph against the state government and the central government that they both are fighting, and by virtue of the ONGC clause they were not responsible. As such, 1 lakh rupees cost may be imposed on them. In normal court, they are supposed to be my writ should be allowed. Instead of that, they have written only because of that I have come before Your Lordship. Your Lordship may see this learned single judge's order. That's why in my note also I gave the concerned paragraphs. At page number 21 of my material papers, middle of the paragraph. The other provisions of the Act may not be relevant for the purpose of the present inquiry, except Section 23, which authorizes the state government to direct by a notification that any reserved forest or any portion thereof shall cease to be reserved forest with effect from such a date as may be notified. From the above analysis of the provisions of the State Act, it is clear that the state government is vested with the power, both constituted as a reserve forest as well as denotify any area which is already constituted as a reserve forest. It is this power of the state government to denotify any area which is already constituted into reserve forest that is restricted by Section 2 of the 1980 Act. Prior to the commencement of the 1980 Act, there was no embargo on the powers of the state government to delete any of the area out of an area constituted to be reserved from the barring the embargo or the bona fide exercise of such power. This is the legal position emerging from the analysis of the above 2 enactments, which is required to be applied to the facts of the present case. It is unfortunate that the various departments of the government of the state of Andhra Pradesh, departments of the government of the state of Andhra Pradesh do not work in harmony. Insofar as the land in question is in dispute, in this case is concerned, the forest department represented by respondent number 2 and 3 asserts that the land is a part of the reserve forest by virtue of some notification issued in the year 65 and 71. I proceeded on the assumption that as a matter of fact, the lands disputed were notified under AP Forest Act, constituted into reserve forest as claimed by the respondent number 2 and 3. The revenue department, the respondents 4 and 5 of the state of Andhra Pradesh thought it fit to alienate the land in favor of the petitioners under government orders.
Please argue where.
Pardon?
Please argue on the issue where the learned judge held in your favor. Only that particular para.
At page number 23, middle, Your Lordship. Therefore, it starts with this. Therefore, by the time of the Parliament made Act
No,
of
no, 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 no.
1980.
Read up.
Pardon?
Sections 1, 2, 3, 4. Just
Wait,
submission so that we can.
Section 20 with.
No, no. Please see the second para, starting with D horse. 1, 2, 3, 4. Fifth line onwards, notwithstanding the sanctions. Please read from there.
They are the provisions of the Act of 1980. Your Lordship, is that?
Yes, yes. Please read from fifth para, notwithstanding the sanctions.
Where
You
is
can
it?
skip that.
Yes, Your Lordship. Enumerated in the Section 10 of the State Act are prescribed activities indulged in the attract the penalties of both imprisonment and fine. Cutting of trees, clearing or breaking up of land for any purpose, and some of the activities prescribed in the Section 20. Notwithstanding the sanctions created by the legislature against such activity in the reserved forest, the state of Andhra Pradesh thought it fit to alienate the land disputed in favor of the petitioner for a specified purpose for construction of an ash pond purpose, which is inherently inconsistent with the scheme of the Section 20.
That's all. That's all. Which is inherently inconsistent with scheme of Section 20.
Your Lordship, permit me to read the
Yes,
terms,
read.
Your Lordship. While the purpose of the Forest Act is to preserve the forest in state of Andhra Pradesh, which is felt necessary in the larger public interest, obviously the government of AP believed that an equally competing of superior public interest exists in enabling the petitioner to establish a thermal power plant. It is therefore alienated the land in the dispute in favor of the petitioner, a decision of which is undoubtedly within the powers of the state government assigned to it under the Constitution. In which case, such a decision, in my view, can only be treated as a decision under Section 23 of the Act to delete the areas in dispute which till then formed a part of reserved forest. At the time of such a decision, the state government made an alienation subject to only to one condition of payment of monetary consideration. Therefore, by the time of Parliament made the Act of 80, the land in dispute stood excluded from the purview of the operation of the AP Forest Act. Hence, the 1980 Act of the Parliament, in my view, would have no application to the lands in question, which stood already excluded from constituted reserve forest under the State Act.
Madam, that's enough. You make your submissions on. What we prima facie find is that there is no finding in your favor, which is why the writ petition was dismissed. Even here also, it says that inconsistently, it is inconsistent with the scheme of Section 20. It is, which is against the finding.
Then later, Your Lordship, it passed on because of the government not cooperating between the state and central government. They are supposed to pass a notification, which they have not done.
Anything else?
Nothing else, Your Lordship.
So what are your submissions? That submissions are that all the findings are in your favor, yet petition has been dismissed.
My only submission.
That's the only submission.
My only submission is because of 1980 Act is not applicable to me. The question of the rest of
Therefore, the order of conversion granted in your favor should be quashed. This is what you have said, madam. Read at least the amendment.
I'm saying that, Your Lordship.
Not saying this is the amendment you have. We don't know. You are not even reading the amendment. Read the prayer. Read.
Your Lordship.
No. Read the prayer.
One more point I will submit, Your Lordship. I understand there are two GOs and one enactment has come. The GO yesterday I passed on to Your Lordship. All the areas which were given for non-forest areas, it is not necessary to take the permission of the forest department, and they are deemed to be excluded. And then not necessary a forest compensation also. That's how it was.
Fine.
I got the.
All right. Thank you. This WA number Huh? 1 minute.
It's not in the difficult.
Huh?
Very difficult.
Which case?
29.
29.
I am not petitioner, my lords. Kindly posted to.
Learned counsel for the, why 23rd?
Yes.
Next, we will adjourn it. 29.
So I don't want to take one.
Yes, yes. We will adjourn by 2 weeks. Don't worry. 3 weeks. Learned counsel for the, why?
Monday.
You are an outstation counsel.
Okay.
Then after 3.
The subject on the previous Sunday will be better for my. I adopted this.
No, we are not saying anything. You are in a critical situation. We are adjourning it. Not giving any date. Learned counsel for the petitioner prays for
Bless.
lunch motions. We take it up. What your case is in final year?
Cases, my lord, they are in the hearing. I request the honorable court to kindly take them up on Monday, my lord, at 2:30.
Which
They
case?
are at item numbers 198, 199, 200.
Oh, it won't reach today. Let it be. Let's see.
Your lordships may kindly have, because issue of 1994, my lord, I have been waiting. Monday, your lordships may kindly accommodate. My lord.
Which case? We don't have.
198, 199. I have taken the concurrence of the Advocate General also. my lord. Number 198, 199.
This is hard. This is 2023 matter. That's
New
why.
matter, my lord. It is not yet admitted,
Ah,
but somehow it has gone into the caption for final hearing.
ah.
It is not admitted and it is actually a fresh matter. my lord.
So what you want us to hear it on admission?
Yes, my lord, your lordship, because it is already, anyway, on merits, my lord, I'll make submissions if my lord give me a date. I request your lordship, my lord, to kindly hear it tomorrow or Monday, my lord,
No,
whichever
it's
day.
not. This is 23 matter, Mr. Why?
No, my lord, it
What is the
not,
urgency?
not yet admitted, my lord.
Also, we will list it for orders on admission. Here, Advocate General, if a case for admission is made out, we will admit it. Learn it so and so, 198, 199, 200. Learn it Senior Counsel for Respondent points out that even though these writ appeals have not been admitted for hearing, however, yes.
Your Lordship, I have responded by filed the additional affidavit withdrawing the surface proceedings. Hence, the writ is inspection, Your Lordship.
You want to withdraw this writ petition?
No, they filed that I am the respondent bank. He is the petitioner.
I am the writ petitioner. I have challenged the 13-2 notice.
Ah.
They have gone ahead and withdrawn the 13-2 notice.
Learn it.
With a liberty to issue this notice.
In this writ petition, the petitioner has assailed the validity of what have you challenged?
The post-remain as well, yeah.
Validity of the demand notice dated 2/3/2020 and notice seeking possession. Yes.
May it please, my lords. My lords, challenging the order of the learned single judge. My lords, wherein I, due to orthomotor disease, I couldn't complete 75% of attendance. It was 72%. I gave my representation to respondent. Without considering that, my lords, they passed an order on 27/9/2023. Exams were to commence from 29. I couldn't write 2 exams. When I approached before this honorable court, learned single judge, having found fault with the order, directs them to consider my representation when my exams are going on, my lords. I have already missed 2 exams because they did not.
No, Mr. They see one thing you should be clear when you, the responsibility on you increases when you because we have not read the file. Don't argue as if if it would have been included in tomorrow, we would have read it.
I'm sorry.
Don't, the burden is not on all the time on the court to this thing. If we don't understand your case, we will dismiss. You have not told the facts. You have only told us that writ petition has been disposed of, examination is going on. And 75% attendance you have not fulfilled. So what is wrong? If a rule provides you don't fulfill the attendance, then that's fine. What can we do?
Facts are like this, my lord. I was pursuing the veterinary science course from the academic year 2022 to 23. My lords, because I was suffering from orthomotor disease, wherein because of which, as per the regulations, my lord, attendance is 75%. Because of the disease, my lord, medical grounds, I could not fulfill the criteria of 75%.
No. Is there any provision for relaxation?
That provision is there, my lord, as per their own rules. Page number 33, my lords, it starts. My lords would find it at page number 40.
What disease you are suffering?
Orthomotor. Rheumatology disease. The medical certificates are
Rheumatology. What, like pain in the bone?
Yes, my lords. My lords may see the certificates at from page number 24 to 20. Page number 20.
No, you show us the provision first.
Yes, my lords.
Relaxation.
Yes, my lords. My lords may see page number 46, my lords. (46) 10.7, my lords. A, if a student may I read, my lords.
Also,
yes, my lords. B,
what decision have you taken on his representation?
Because the letter judge was used to pass order yesterday, Millet. It was communicated today to the. They will take, committee has to cancel, they will take the decision by tomorrow because the letter judge granted.
So what happens to the examination then?
Page 46.
Mr. 75% is requisite attendance. He has attended 72%.
In one subject, Millet. There are in several subjects, Millet, petitioner lacks the attendance. In one subject, she got only 62, 65, 69. And even as per the regulation, even the VC has no power to relax the condition. Page 40.
No, let her appear. Let him or her appear in the examination. Her appear in the examination. Nothing will happen.
May I just say only
You
one.
decide.
May I just say only one. Page 46. 10.7b, Ulashima may kindly see. A student who wishes to seek relaxation of the above provision may apply to the associate dean, giving the grounds and proof thereof to which he should not.
No. So 48 hours. This thing.
Pardon?
You have to take a decision within 48 hours.
Yes, Brad. But even only the provision is that we can give the re-admission to the petitioner, but we cannot.
No. We are talking about learned single judge's direction.
Milord.
48 hours you have to take a decision.
Yes, Milord. It was only the copy was made ready only yesterday evening. It was already communicated. I instructed the university to take a decision as per the directions of the
University will take time to take decision. It will let her appear in the examination. Nothing happens.
Tomorrow they are going to consider. The committee has to consider.
No. They will consider at 11:30 p.m. By that time, examination will be over. Do you undertake, Mr. In case the appellant succeeds in the writ appeal, do you undertake that you will hold a special examination for her? What is the harm in permitting her to appear? You take your decision. See, Mr. You have to be meant for students, right? You are not like anti-student approach all the time.
We are not against the petitioner because
That's why.
it also does not give the power to the university to relax the attendance. At the most, we can give the re-admission to the petitioner to the first year instead of again driving the petitioner for appearing the MSET
You are
examination.
which semester examination?
My lords.
Which semester?
First semester. Annual exams, my lords, for the first year.
First year. How BVSC courses which year? How many years?
5.5 years, my lords. BVSC 5.5 years. Academic year 2022. I took it.
This is your first semester.
Yes, my lords.
So then that shows how will you complete BVSC? So every time to the High Court. That's it.
No, I'm taking
because you are not. You will never complete the classes and dependent on the High Court, right?
No,
for the completion of your course.
I'm taking medication, my lords. I'm recovering from it.
Recovery?
I'm recovering from it, my lords. I'm taking medication. Slowly I'm recovering, my lords. I consider it, my lords, as one time this thing.
So next year you will not file, right? You will not file the petition. One time means next year you will not file the petition seeking exemption from attendance,
Lords,
right?
if God permits, I cure from the disease, then I will attend. If I recover from the disease, then I will attend the class, my lords.
Which disease? Just 1 minute. Show which disease.
At page number, my lords.
Page
24, my lords.
24.
Rheumatoid.
Progressive.
Page 24.
Systematic. What is it like?
Pain in the bones and hands, my lords. Then I went to government hospital also, my lord. ESIC.
Medication. Like it's saying like diabetes. Huh? Even 60% is sufficient. What is the disease like?
My lords.
What happens? You have any idea?
My lords, pain in the bones and all that, my lords.
So when is the examination?
Tomorrow, my lords.
Tomorrow means only one day.
No, from tomorrow it is there, my lord.
Already
Already it started from till 12:10. Page number 23, my lord.
So have you appeared in other papers? No.
Previous two papers I couldn't appear, my lord, because on 27 they issue this.
Which paper?
Paper number, my lord.
No, like when the this thing's examination has been held in two subjects.
29 and 3rd. 29/9/2023 and 3rd October 2023. That was yesterday and on Friday.
So what happens like if you don't appear in two subjects, then carry forward, right?
They may allow me to write supplementary, my lords, if I succeed in the writ or so. Because, my lords.
So like if you don't appear in two subjects, you can appear in supplementary examination.
Supplementary.
It is held supplementary.
No, there is no supplementary. It's only 6 months. Once in a 6 months, my lord, examinations will be.
I was informed that for one exam, one or two exams, if we don't appear, they will conduct supplementary exam, is what I was informed.
Where is the provision? Informed means you like information with the court can act. The court of law can act on the information supplied. What do you?
No.
Then there has to be a provision. Then what is the use of permitting you now? If you have missed appearing in two subjects, like what is?
My respectful submission is this, my lord. Yesterday I approached this honorable court.
You should have, you knew that 29th September, this date examination is going to be held. When did you approach the court?
My lords, on 29th I was communicated that I am not eligible. By the time I could approach this court, it was too late in the day, my lord, from the 29th. And Saturday, Sunday and Monday been holidays, my lord. They communicated that on 28th, my lords knows there was holiday.
But Mr. You are right. You understand why we are asking this question.
Yes, my lords.
Supposing even if we permit you to appear now,
yes, my lords.
What will happen? Two subjects you have failed. I mean, like you will be treated as having failed because you have not appeared.
Yes, my lords.
So whether any provision, what is the use? Or you will have to repeat. What does the regulation say?
It says that I have to repeat from the first year again.
Yeah.
My lords, I will take that risk, my lords.
Risk means what risk? Regulation permit or not? Please tell us.
Lords, as per my
that any supplementary examination will be held, one subject, two subject, whatever. Please understand, we are.
Yes,
my There's no point in making a futile attempt, right?
Yes, my lords.
Whatever has happened. You can sue them for damages and whatever at the 11th hour for wasting 1 year. Where is the provision that supplementary
compartmental examination is there, my lord.
Where is that?
Page number 53, my lords.
53. Compartment.
A student
failing in maximum.
Two
No, okay. Correct. this intra-court appeal has been filed against an order dated
So medical admissions, my lord. Lordship's order 20, page number 25.
20, 20,
25, my lord.
25, 25 certified copy today.
Similar order.
25.
Yes.
Certified copy today. Age, madam. 25. Certified copy today. Yes.
Page number 16, ma'am.
16.
160.
Certified. $30. 333. All right, disposed of copy today. Mr.
Page number 18, my lord.
18, 18.
Yes, your lordship.
Yes, Mr. Rao. All right. Yes.
Page number 14, my lord.
14.
Yes. Page number 18, your lordship.
18.
Public.
All right. Disposed of certified copy today.
May I please? My lords, in gynecology, there are 8 seats. Quotas. Quotas. Okay. There are 8 seats available in gynecology. 3 in Gandhi, 3 in Kakatiya, 1 in Nizamabad and 1 in Mahbubnagar.
So what?
Should be willing to take
8 seats are available.
In Gandhi, there are 3. In
total 8 seats.
8 seats are.
Gandhi Medical College 3, then 6.
Well, I passed on a sheet which is highlighted.
So, these are vacant.
Yes.
And you should be admitted.
Yes.
3 Gandhi Medical College, then
Gandhi, Kakatiya Medical College, there are 3. In
3.
These are all government colleges. Then Nizamabad Government College, there is 1. And Medak Medical College, there is 1. Mahbubnagar, I beg your pardon.
Medak.
Mahbubnagar, there is 1.
8 seats.
That's
so, and you should be this thing. They have not categorized, no provision has been made. And therefore, if the provision is made, you are entitled.
I would be entitled to one of these.
Should be implemented. These 2 orders.
Yes. That's my case.
Yes. This one.
Tobacco? Tobacco?
No. So what do you say, Mr. No vacancy you want to say? No vacant seats. No, but she is the SC candidate, right? One lakh. Gynecology and no, but she is not claiming on the basis of merit, right? Uh, uh, uh. Hmm. Less than 100 rank. Hmm. So not so. What is your submission? No, do you mean to say that no candidate less meritorious than the petitioner has been admitted? What is? No, you what? How do you meet this submission? That the order passed by previous two orders passed by this court direct that she should be treated as person petitioner should be treated as third.
Petitioner was allotted where the EIS Medical College, where the emergency medicine. It was one of the options given by the petitioner. Otherwise, on merit, she is not entitled even the any seat.
No, this is not a claim based on merit. If she would have secured first position, no question of filing the petition.
Yes, Lord.
She would have got wherever.
That is the reason why we are considering the orders passed by Honorable Court and considering our status, where seat was reserved in our favor and allotted. That is the option given by her.
That is the argument that no provision has been made. You said that it's for the central government and state government to make up.
Both the states did not make out any reservation, special reservation among the caste which they belong.
And actually, my friend is not right.
It was appeared in the press. I also stated in the affidavit that the petition was filed before the Supreme Court seeking horizontal reservations in a caste to which the transgender belongs. That's not accepted with Supreme Court. Let's kindly see.
Nalsa judgment.
Nalsa judgment. As per the Nalsa judgment, an application was made before the Honorable Supreme Court seeking horizontal reservation in a caste in which transgender belongs. That was not accepted. Vertical reservation is not possible. Only horizontal reservation have to be worked out.
Whereas on that, a contempt is pending before the apex court. Notice is ordered. They were asked to tabulate the results.
Let him, yes.
Sorry. Therefore, as of now, the position is, that the reservations are not made out. The university, as per the orders of this Honorable Court, has allotted a seat. Considering one of the options given by the petitioner, seat was allotted to her.
So no. But one thing, Mr. Rao, we would like to be sure about is that the order says that it has to be provided in a matter. She is a third and a scheduled caste. So the order says more beneficial. So supposing you have given her emergency medicine, whether she would have got it as SC candidate?
No. That is also affidavit stated. But the last rank that was secured.
SC category.
Yes, Lord. Secured by 62,073.
62,073.
Last rank secured by SC candidate.
So this is your submission that even under SC category, she would not have got it, and interim order, emergency medicine, therefore you have granted.
Yes, sir.
So like the claim for admission to this thing, gynecology, what?
That the seat matrix were already, seats were reserved in favor of your
No,
candidate.
but is it this thing that 8 seats are available to be allotted?
The seats are
Vacant.
not available. Seats
Not vacant.
not vacant, my lord. They are reserved in favor of the candidates.
No. Say reservation in favor of candidate and not filled up. These are two different things.
But they exercise their options. Morning onwards, they are exercising options. But the candidates in
No, so what should we? He's saying that these seats are vacant.
in
The
case
document that is given to your lordships,
in case of-
see that document.
in case of end of mop-up round, in any seat is vacant in gynecology, that university may will consider.
Your lordship may see the document that he's just given your lordships.
No,
What
no.
does it say on the first line? List of available seats for mop-up phase of counseling.
Yes, sir.
So these are the seats that are available. One, factually incorrect in saying that no candidate with marks less than her, rank less than her have got a seat. A person in service candidate scheduled caste has got a seat who's got a rank less than her. So he says that people
No, this like we feel that it's incorrect statement.
yes,
62,007
it's not that.
73 is the last rank under SC category.
No,
In the affidavit I said.
I have said, but he has said that the last rank went to 62,000 SC category in PG seats without referring
No,
to.
but still, one thing we would like to understand from you, what is the legal right to claim admission in gynecology?
That's what I'm saying.
Particular branch. See, his submission, if you will have to meet legally his submission, he says that you belong to two categories. One is SC, another is third gender. So he says that even assuming that if we would have treated her as SC candidate, she would not have got admissions. Therefore, third gender status we have accorded and benefit we have accorded and admitted her in emergency medicine.
That's what.
And second is no candidate less meritorious than her has been admitted. And under SC category, 62,073 is the last rank which has been admitted. This is what.
I'll answer both those questions. In so far as the first
First, we want to understand what is the legal right of claiming admission in gynecology only.
I am saying, in the absence of your creating any window for transgender, this order was passed. Because if you had created in your matrix a seat for a transgender, I would have automatically walked into that. Because I was the highest transgender marks person in the examination. One, your failure of not creating any seat for reservation for a transgender in accordance with that judgment is illegal. My argument would be that after the Nalsa judgment, when you create a matrix, it's easy for the university to say, I am not governed by what the Supreme Court said, I am governed by what the central government says and what the state government says. But my rights flow from what the Supreme Court said, namely that while you are giving seats, please provide for these people also. It will be
This is, Mr. This is you are arguing finally. It's on IA. Please understand.
context, my lord. It is in that context that today.
We are hearing you on IA 7.
That's
The IA 7 relief is grant me admission in MS.
So that in that context, your lordships wanted to find out how many seats are left in the map-up. In the pre-lunch session,
We did not use it. It is we.
I told lordships there are a few seats available. There was a statement from across the bar saying there are
No, he has considered to the extent that if any seat are left vacant,
No,
we
they
consider.
everybody else has taken it. So that is no concession at all.
Yes.
That's no concession at all. And the seat that he is giving me in emergency medicine.
No. So we have understood that no provision for this argument we have understood.
Yes, no
And if
provision.
you are the most meritorious candidate, therefore it automatically.
Transgenders, I am the most
Of
meritorious.
course,
Among the transgender, I am the most meritorious.
meritorious.
You have not provided anything. And thirdly, even the emergency. And even the emergency medicine seat that you're giving me was not reflected in the matrix. If you are not going by the matrix, then I might as well get the subject that I choose rather than a subject that I don't choose.
What is your submission with regard to this particular statement which we just told you?
About 62,073. That is admitted. That is
No. So like this is admitted. So therefore, obviously they have interpreted this order in a more favorable way and have given you admission in MD medicine.
No, to favorably interpret that order of the court, they would have had to find a matrix space for me. There is no matrix space at all. That is where there is a violation.
No. So for violation, they will be punished, no?
Where that help?
That will, no. That doesn't mean that if two orders passed by this court are lacking somewhere, we should issue a third that. Then again, consequently follow contempt, again another contempt.
I'm only saying this. That is where your lordship's statesmanship would step in, my lords. Because tomorrow, if they are punished for not following this order, then this is going to.
No. The effective relief is to implement those orders like two earlier orders. So therefore, we should pass another third order. This is the prayer.
How I would interpret that prayer of mine would be this one. My submission to your lordship would be this. As of today, I am coming before your lordships, showing your lordships, that there's a large scale violation, but I'm not saying punish them. I am saying instead of punish them,
They can get away by giving you admission in MS gynecology. That's the only way out from them.
Here is a moment when probably a corrective mechanism can be done and the petitioner will also be satisfied. Substantial justice would be done. It's too archaic an argument, my lords, and it's a troublesome argument to come before the first court of the state and say, we are stuck on merit, because if you're stuck on merit, a number of people over here on considerations other than merit have got it. For example, how does a person with 62,000 rank get...
Mr. Please understand, we are dealing with your specific prayer in IA to grant admission in MS gynecology.
This argument of mine was only in the context of my friends.
Even admission, it was understandable, all this argument. According to them, they have complied. I am not disputing that last rank in SC category was 62,000. Despite you have scored over 1 lakh. Despite that, you have been admitted in this thing, emergency medicine.
What is this? What's that? But now I have to show that rank number 1,18,142. Totawar Mamata has been given a seat OUPCD in MS Gynecology and Obstetrics, Gandhi. Sirs, you said no person with the lesser rank. Now you are bringing in a new category. He just now said no candidate. His argument was that there was no candidate with lesser rank. I'm showing your lordship that there's a candidate with lesser rank who's got a seat.
No, that is different category in service.
In
your this thing, no person.
That would be begging the issue, saying that I am a category that you ought to have made, you did not make, you have given, for which their answer is, we are looking at merit. If you are looking at merit, then a service candidate who got less rank than me, who has been working in the government.
No, but you don't dispute in service. But these averments we do not find in the application, etc.
Argument that
but
was
like in service is, she is in service, right?
Yeah,
and,
that's
yes. And you are not in service.
Not in service. Okay. I'll leave it to you, lordships. This is so far as the writ is concerned.
So far, repetition.
So far as the content is concerned.
No, we are deciding, we told you.
only the
Council IA 7.
Yeah, only
Contempt,
the
we said no, that we will decide later on.
Yes.
When we hear the writ petition finally, you can say that my writ should be heard urgently. We are deciding IA.
Yes. So the, no,
Dealing with your claim for admission to gynecology.
Yes, I understand that, but what I'm saying was, next to that is the contempt case. Just adjourning it, so I have no problem.
No, not adjourning means you said it can be decided later. You first half of the day you said. That's why we will decide it today just now. What is there?
So far as the contempt is concerned, nobody else has filed a counter.
I sent the counter for signatures.
Central government.
Contempt.
Contempt, I have not taken notice.
Not a party.
They are a party, they're all parties.
Huh? They're not university. Contempt, we are talking about contempt. Mr.
Contempt, because contempt not getting vakarat not from the artist.
University did not receive the copy.
Notice has been
Notice was
issued.
issued.
Then you appear.
I verify.
Then file counter in contempt.
Very.
Why are you not filing?
The contempt.
It's a serious issue, right? Contempt. So everybody has except you, everybody else has filed count. No, we are talking about contempt.
I'm not proper, not respondent. Every party.
We don't know, Mr. All right, contempt you write by 2 weeks time by way of indulgence is given to the Next. Yes. 2005.
Please, your lordships.
Ah.
Lord, before I make my submission, I'd like to answer these maps. Of course, this gives only a brief note, Milord. The details I would like to submit. Yes.
So you are happy with the revised demand notices, correct?
No, my lord.
But
That
you-
also we are
No, but,
challenged.
you have said petitioner asked third respondent to issue revised notices.
Yes, my lord. Yes, I do understand. But even with regard to the revised demand notice, we have that also we have challenged in the writ petition
No, no.
on certain grounds.
But you agreed, right? You asked them, see, after hearing you, amount of 30 crores was reduced to 10 crores 29 lakhs. And seemingly from your note given by you only,
Yes,
it appears that you are happy with 10
No,
crores.
no, my lord, it's not that.
But then why
That's
do
why
you-
I said, my lord, I will.
But last line you read in your this thing, what have you said?
No, we said that they are under challenge, my lord. Both.
As the time was running out, petitioner asked third respondent to issue revised notices.
Yes. And that is under challenge, my lord. Both.
No. So revised notices means what inference? The inference that is that you had accepted
No,
10
no,
crores.
my lord, not that way. Your lordship may kindly see.
But this is your note is creating confusion, madam. Last line.
I am
Please read.
sorry for that. Yes, ma'am, I understand. I'm sorry, but your lordship may kindly see. The prayer is very clear. We have very clearly challenged both the demand notices. Both 30 crores one and also 10 crores one.
30 crores does not exist, madam. It is revised to 10 crores.
My lord, your lordship may kindly see. Now, if your lordship sees the 10 crores one also.
We haven't seen the file. We have only gone through the note given by you.
I will take your lordship through the affidavit also.
So you have yourself said in last, please read, madam, what do you give to judges? You don't read it and then tell us. At the bottom, you have said that the seventh respondent revised the amount from 30 crores to 10 crore 29 lakhs. That means if he has revised, 30 crore does not exist. So there is no question of challenge of 30 crores. Now only 10.
No, it's not so. The 30 crores also exists. That is under challenge in the writ petition. Your lordship may kindly see my prayer. Your lordship may see my prayer.
No, that means this note is not correct, right? We
Okay,
should
my lord.
discard.
Then I'll submit. I'll submit.
No, then you have to see what have you written here.
Maybe the last it is not correct.
Revised to this then and then you, this thing petitioner asked third respondent to issue revised notices. So this gives a suggestion that you are accepting 10 crore. Now you are saying I am challenging. So this is not correct, right? Whatever
Yes,
you have
then
given.
I'll make my submission.
No. You have to say it's not correct. You are giving it to the court.
No.
We will.
Maybe the last paragraph.
It is signed by you.
Yes, my lord. The last paragraph is not perhaps correct. I'll put it that way. As far as the challenge is concerned, all the other facts are only from the affidavit, whatever is there in the writ petition, except the last paragraph, because both the notices are under challenge.
What ground, madam?
Grounds I will submit, my lord. May I submit the facts?
Yes, please.
My lord, as already given in the note, the government was supplying bamboo and hardwood, both to the Bhadrachalam paper boards. Now, of course, it got amalgamated in 2002 in ITC. Then, my lord, there was a revision of royalty rates. Then, by challenging that, we have gone in a petition before this honorable court, that is the previous AP High Court. Then the petition was dismissed by the learned single judge. Then against that we have gone in appeal. Writ appeal also was dismissed. Then we went to Supreme Court. Because finally in the year 2002, Supreme Court also has dismissed our SLP, my lord. That is how it fell into arrears, all these things, because there were interim orders where we had to deposit 50% as per the rates that are specified by the court. We have been depositing the amounts, but the rest of the amount we have been giving the bank guarantee. Now your lordship may kindly see In fact, the writ petition was, SLP was disposed of in 2002 October. And in 2000, by December, they have encashed the bank guarantee. Practically, there were no arrears from the company. Now, from 2004 onwards, repeated revised demand notices were being issued, demand notices and revised. They are filed in the paper book. Or to make it easy, my lord, I will draw your lordship's attention to page paragraph 17 of the affidavit, my lord. Where we have given the notices that we have filed also in the paper book. Paragraph 17, one demand notice dated 8/11/2004 issued by fourth respondent, and revised demand notice dated 22/12/2004 issued by fourth respondent. Demand notice dated 1/12/2004 issued by fifth respondent. Demand notices dated 10/12/2004 issued by sixth respondent. Like this, my lord, there were 8 that were issued. Now, all these things belong to different divisions issued by respondents 4 to 7. So finally, the third respondent has issued a demand notice that is 30 crores and odd, referring that includes the demand notices of respondents number 4 to 7. That is there in material papers, page 3. So finally, my lord, when this was given on 12/1/2005, consolidating all the demand notices of respondents 4 to 7, a total amount of 30 crores 87 lakhs. We gave a representation dated 11th February 2005, filing all our objection in that and also asking for a personal hearing. That representation is there, my lord, dated. That is by way of reply, material papers, page 18. Lord, we gave the reply and we also requested for a personal hearing. But they kept quiet, and meanwhile another demand notice for the same amount was given, and on 12/5/2005. Thereafter, we again represented And we said we need personal hearing. Then the third respondent directed the seventh respondent to look into the matter and pass appropriate orders. Now that demand notice in our contentions were partly allowed. All the contentions, whatever we had, were not taken into consideration. And taking our claim, the contentions partly, the demand notice was issued for 10 crores, my lord, that is at material papers page 1A, which is the total amount is 10 crores 29 lakh 16,444. Thereafter, my lord, what has happened is, this does not say, though we were informed that it is in respect of all the divisions. As I already submitted, my lord, all the respondents, that is respondents 4 to 7, went on issuing demand notices. That I'll draw your lordship's attention to. Page 28, my lord. This is Office of the Divisional Forest Officer, Paloncha. And page 30, Office of the Divisional Forest Officer, Logging Division, Bhadrachalam. And 37, my lord, is the Office of the Divisional Forest Officer, Logging Division, Bhadrachalam. Again 38, Office of the Divisional Forest Officer, Logging Division, Bhadrachalam. Why I am submitting these things is, my lord, they went on giving revised demand notices. So we were not in a position to know what exactly is our liability. So we wanted a personal hearing. Personal hearing was given, but still all our contentions were not taken into consideration or not allowed. And this demand notice of 10 crores and odd was issued. Then thereafter we wanted the third respondent to issue the revised demand notice stating that, because if your lordship sees, the revised demand notice at page 1A does not say anything. There are no details. We were only informed that it pertains to all the divisions. So we gave the representation at page 1 below to the third respondent. May I just read that below? Pursuant to our reply notice 4 cited above, the DFO Paloncha granted us a personal hearing, partly accepting the contentions raised by us in the reply 3rd cited above, and consequently revised the quantum of amount released to be paid by our company towards interest on the elite arrears of royalty. As per the said revised notice, the demand on account of aforementioned interest stands at 10 crores. The 10 crores 29 lakh 16,445. The DFO Paloncha informed that the said amount consists not only the demand pertaining to Paloncha division, but also it consists of demands pertaining to Bhadrachalam, Logging Division, Bhadrachalam South Division, Bhadrachalam North Division. In view of the above, the demand notices, first and second cited above, are required to be revised in terms of revised demand notice. If cited above, we request your good selves to kindly. This is the representation given to third respondent. As we did not get any reply or response for this, we approached this honorable court. And then, my lord, we have challenged both the demand notices of third respondent as well as the revised demand notice of the seventh respondent. My lord, now your lordship may kindly see the grounds we have raised. Here, the first thing is, my lord, the 30 crores
Have you disputed the amount?
Pardon, Milord?
Have you disputed the amount because subsequently show cause notices were issued? Have you reconciled the liability at any point of time? Because this company maintain all the books of accounts. According to you, what is the liability?
Milord, it is definitely not that. Milord, as far as your lordship may kindly see, the 15% interest is levied both on bamboo as well as hardwood.
That's fine, madam. Whatever it is, you must be maintaining a parallel ledger account. According to you, the books of the company, how much you have to pay in terms of the royalty?
No amount, the royalty is not in arrears, Milord. That's what we reconciled in the personal hearing.
No.
So now the issue now is only with regard to the interest. That's what I am submitting. The issue now is with regard to the interest. That's why, Milord, your lordship would appreciate the 30 crores demand notice of whatever was given by third respondent that has come down to 10 crores. Only because there are no arrears. In earlier demand notices, they went on including even these arrears also. Now the dispute is on 3 aspects. That is, one is interest, and they have also not taken into account the 50% of concession that was given to us by government has given 50% concession in the royalty.
You ask how much according to you the liabilities. It's not 10 crore, whether it's 4 crore, 3 crore, 1 crore. Out of there, you have to recover 20 crore. What is it?
Madam, see, I am repeating the question again because this is a continuous cause of action.
Yes.
There has been royalty which you have to pay every year.
Yes.
Company maintain books of accounts.
Yes.
Is there anywhere it is clarified that this is the principal amount we have to pay, this is the interest, or in terms of the due? There must be a comprehensive representation. We are unable to figure out what is the actual liability, whether the ITC has to pay or the government has to pay back.
I am not saying that, but here your lordship would see the demand notice at page. That also talks only about the interest part of it. The statement, your lordship may kindly. Lord, your lordship may kindly appreciate, first of all, we are in fact one of the grounds we are saying is that the government has waived its right as far as claiming interest also is concerned.
This.
And all the amounts were paid by us.
Divided 10. So what is
we have, in fact, it has.
No, if you are disputing 10 crore, the question is very simple, madam. Either you have not comprehended or you don't want to answer. These are the only 2 possible inferences. What brother has asked is that they are asking you to pay a sum of 10 crore 29 lakhs and odd rupees on account of interest. You are disputing that amount. According to you, what is your liability? That is the question. Whether you owe 4 crores or government has to pay you the amount. What is it? What is your stand? Apart from saying that it's not done, that done,
no,
this
no,
is done.
I'm saying that in fact
That's what brother said, that you maintain books of accounts. As per your books of account, what is the amount due on account of interest, or it can be no amount is due. I have to recover amount from the government. Something like that.
I don't say that I have to recover, but one thing will.
What is the amount then? That's the question, query.
Yes, but that particular clarity is not there as far as the affidavit is concerned, my lord, even our reply. I do agree. I'm not saying anything with regard to that. That particular figures are not there. But our contention is, my lord, here one more aspect that is to be taken into your consideration is the interest component has come only because we have gone to the court. Otherwise, your lordship would see when it was revised, we agitated the matter. Finally, the matter went up to apex court. That was our contention was not upheld. But I got it calculated.
You have the repository.
Have you deposited, have you completed the order?
Yes, yes, my lord, definitely.
3 crores.
3 crores and bank guarantee also was furnished. Yes, they have completed that. We have completed then and there itself.
Yes, sir, you have to say what is the liability, on what basis you are issuing notices one after the other.
Clearly mentioned millet here.
One.
1A millet. One small A. Millet para 2 millet. The Honorable Supreme Court of India in CA number so and so has delivered its judgment advising the ITC BPL Sarapaka to pay the royalty indicating the rates for the material supply, that is bamboo and hardwood. In view of the above judgment, the amount due to the department has been calculated for the year 1980-81 to 84-85. The details of the amount payable, paid and balance to be paid along with its interest on the due area amount is enclosed in a statement which is reconciled with the BPL. Kindly see the next page. This is only with regard to interest, but the royalty has already been paid. Kindly see for a second. Year 1980-81, quantity of the bamboo has been mentioned in the third column. Period of supply is in the second column. Fourth column, rate charged. Amount royalty payable, this is not in dispute, they have already paid. Amount of royalty paid before Honorable Supreme Court judgment, that is 10 of 2010.
Yes.
And payment of interest, your lordship, kindly see column number 9, that is 15%. This is millet as per the agreement. I'll take your lordships to millet the agreement also. That 15%. And finally come to millet column number 18, 17 and 18. 17 talks about royalty. Royalty is 0, they have paid after losing millet the matter before the Honorable Supreme Court. Then the interest portion is at column number 18 millet, that is 831 lakhs. In the next page millet, for the balance years, similarly millet, we have indicated everything, period, amount, chargeable interest. Kindly see millet at page 24, 2B millet, net balance is 10 crore 29 lakh 16,444. Millet, although millet, this has been filed by the petitioner himself millet along with the writ petition. Nowhere millet, it has been disputed that your period is incorrect, period of supply is incorrect.
That's why the answer to the question was not coming.
Correct. Then let the interest portion also, what we have charged is 15%. It is governed by an agreement between the parties.
Where is the agreement?
Agreement. I'll take your lordships to the agreement. At page, it begins at page 189 minute. 189. It's very old agreement, 20th March 1978. Kindly see page para 33 minute at page 13. At page, internal page 13 minute, internal page 13, running page 201.
It is 208. The clause is 33.
33.
33 is the clause. At 208 in the paper.
May I read? Which page? 33 paragraph. Internal page 30.
208.
208.
It may be 207.
Yes.
Interest at
They
15%.
say my brother's copy is 207, my copy is 208.
But even my copy is also, that's the reason that I kept quiet. My 18 years old files, we don't have the proper numbering pagination. I'm sorry for that. 33 paragraph. Interest at 15% per annum or at the rate prescribed by the government from time to time shall be paid by the lessee on all areas of royalty
and other amounts payable by the lessee. We have rightly charged only the 15%. And when before this was issued, there was an undertaking given by the petitioner himself that whatever you charge, I'll pay it.
Where?
216 million in my paper book, I am sorry, 216 million. This is before issuance of the GO.
No, that is concerned to royalty.
No, undertaking. Yes, taking. Exactly. This is an undertaking given before the GO was issued. Because during that interregnum period, rates were not prescribed. When the GO was issued, GO was challenged by them before this honorable court and a division bench of this honorable court. They lost the litigation even before the Supreme Court.
They have to pay the amount of royalty.
Therefore,
dispute the levy of interest, which is in accordance with the agreement. Agreement and particulars have been given.
Therefore, my respectful submission is that parties are governed by an agreement. There is a clause for charging the interest.
So you have twofold submissions to make, like firstly, all the details of the amount you have been given.
Yes.
Whatever interest has been charged in accordance with the agreement executed between the
nothing is disputed.
And they have undertaken to pay the amount of royalty.
Right.
And therefore, now they cannot dispute the levy of interest.
Yes, that's what my son.
Having paid the amount of royalty.
I'm okay.
Here is a case where not the interest of 15% only is charged. They have charged penal interest. Lordship may kindly see in that. Till that is one of the grounds raised by us. That is one of the objections. Your Lordship are asked you. You have accepted the 10 crores demand notice. We said you cannot levy 22% penal interest. 15% also is for bamboo.
This thing, that saying this thing will not help. Point out from that where 22. Statement P1 is something.
From 1990.
Simply saying will not help.
Page 1B, your Lordship may see. From 1990 to 2002, they have charged penal interest.
No, that is at the rate of 15%, which has been admitted and accepted.
No, that's what I'm saying, Lord. Till that is, as far as the agreement is concerned, 15%. I'm not saying that. When it comes to from column, 11th column, your Lordship may see. Penal interest at 22.5% from 1090 to 12/2002. The agreement does not provide for penal interest. And this is cannot be accepted, Milord.
We have understood this. That's the only point.
That is one thing. As far as
penal interest cannot be levied.
Yes.
So that's what you should say, Madam 1, 2, 3.
No, yes, Milord. That's what I'm saying. Another point is, as far as hardwood is concerned, there is no agreement at all. By executive instructions, they were supplying it. So in that, no interest rate is mentioned.
No, it is the agreement 15%. Back.
No, that is for bamboo. There were two products, Milord, that were being supplied. One is bamboo. This is only for, the agreement is only for bamboo.
But this is.
So then there is no interest rate.
This is only. Details of hardwood, no provision for provision.
Milord, may I just draw your Lordship's attention?
No provision for interest. So what is the third point, Madam?
196, Milord, because the agreement is only for bamboo.
We have understood that there is no distinct provision to levy penal interest. In case of hardwood, there is no provision even to levy interest also.
Yes, maybe Milord.
What else?
At best.
What is the third submission? Then we can go to pages, all pages one by one. But
Yes.
third submission.
The third submission is, my lord, there was a royalty, 50% concession was given in the royalty limit to us. That was withdrawn.
Royalty issue you have lost up to Supreme Court, madam. We
No,
can't.
no, my lord, revision of royalty we have gone. Revision of royalty we have gone. But as far as the 50% concession is concerned, when they have withdrawn, there are two
Again, madam, which you are not answering. Again, we will put you for the third time. How are you disputing an amount of 10 crore? What according to you is payable?
Yes.
Nothing is payable.
No, I do not say that, my lord.
Then what is the amount payable? Tell us your.
The amount is, my lord, they got, it is not clearly mentioned. I am not saying anything with regard to that is not calculated. Because according to us, we need not.
No, nothing. Okay. Nothing.
I'll just submit one particular fact.
Unable to dispute.
This agreement.
So we say that you are unable to dispute the correctness of the amount demanded because you are saying, I don't know.
No, I am not saying I do not know. What I am only saying is we are only on the heads. Penal interest cannot be. Penal interest.
That we have understood, madam. What is the third submission?
Yes, the third submission is there is a 50% concession that is given in payment of royalty which was withdrawn. There is a parallelly one more litigation was also going on. So we agitated the matter when it was withdrawn. A writ petition was dismissed by the learned single judge. Then we filed the writ appeal. Writ appeal also dismissed. When the SLP was pending with regard to this, the government and the company entered into an out-of-court settlement by virtue of which this 50% concession was, the GOs were issued, give us this 50% concession for another 7.5 years.
That has been withdrawn. What else? Was next submission?
That another submission is, my lord, the contract actually came to a cease, that is in the year 88 itself, by virtue of AB, Forest Produce, Fixation of Selling Prices Act 1989. So, as per this act, the contract cannot, Your Lordship may kindly see, more than 10 years, if any contract is there, it will cease to exist.
So it has ceased to exist.
That is in the year 88 itself. So, now only because we have agitated the matter with regard to revision of royalty, and finally it got dismissed in the Supreme Court and we paid the arrears. All the arrears were paid. Now the interest amount is in dispute. That is the only thing. Now, as I already submitted, my lord, Your Lordship, there are 3 points I would like to make. One is the third respondent has not withdrawn the demand notice of 30 crores. That is staring at us in spite of our representation. I am summing up my submissions. Though the seventh respondent has passed the demand notice orders after hearing us. That is one particular submission. So, as far as 10 crores is concerned also, I would like to submit there are 3 grounds. One is the 50% concession that was given by the government by virtue of the GOs that are filed. I have already filed the GOs also in this. That was not taken into consideration while computing the interest part of it. Now we are only on the interest mode. The 50% concession is to be taken into consideration. That is the second aspect. Now the third is, as I already submitted, the penal interest cannot be levied as far as both the products are concerned, and as far as the hardwood is concerned, since there is no stipulation, the prevailing interest rate, whatever is there, that was at that time it was 11%. That was discussed in the context of revision in the writ appeal also. May I take your lordships to that particular portion because it is 11% interest at that time. So it is on hardwood. they have to take only 11% interest, definitely not 15% when there is no stipulation for that. When it is not agreed upon, it is only by way of executive instructions the hardwood was being supplied. May I just draw your lordship's attention to that particular portion of rate appeal judgment? I'm only taking your lordships to the.
I will ask you, must be dated 14 and 33 Jan. There is a case between. No, this, we'll ask him what is the provision of female interest in hardwood. There is a provision for interest. And
18. 91, Milord, material papers, paper book, internal page 18. This is only to draw your lordship's attention with regard to the rate of interest. That's all I am submitting. The last 3 lines. The committee merely took the rates notified for the earlier quinquennium and enhanced the same by 11% for each year of the 5 years in the next.
Madam, which page you read?
91, Milord.
91.
Paper book 91. This is from writ appeal order with regard to revision. In fact, Milord, the royalty was revised based on a committee report. That was being discussed by the division bench. In that context, the interest rate has come. Page 18, your lordships got it, Milord? Bottom, internal page 18.
18, 91, 18. 18.
Yes. At the bottom, I'm only referring to that. I do not want to bother your lordships with regard to that. The committee merely took the rates notified for the earlier quinquennium and enhanced the same by 11% for each of the 5 years in the next. So when they were trying to revise the royalty, 11% interest was taken into consideration. That was the prevailing. When it came to us, for the supply of hardwood, even though there was no specified rate of interest in that, it is only by executive instructions. They can only charge 11%, definitely not below the 15% when there is no agreement to that. Of course, penal interest anyway, as I already submitted in respect of bamboo or hardwood, it cannot be levied. But your lordship would also appreciate, just because I have gone to, either trying to get justice from this honorable court or the apex court, I am being penalized.
It doesn't say so, madam, that you are being penalized because you have gone to court.
No.
This is your argument.
Penal interest. I am only submitting with regard to the penal interest. That's what I am saying. I am only submitting with regard to the penal interest. That what is
that
it?
We will ask him, provided you stop. We will ask him under which provision.
There is, these are the submissions I would like to make. The 30 crore demand notice is not withdrawn, it's not revised, and fresh is not issued. And of course, all the other 3 contentions or grounds, whatever I have submitted. On that ground, even this 10 crores 29 lakhs demand notice also is to be revised, and no papers or documents were submitted or given to us before issuing these demand notices. It is only when we went for personal hearing, we apprised them of our grounds or objections, then they have revised, and then this demand notice is issued. None of the objections were taken into consideration. Your lordship were asking me that I was, your lordship may kindly say wrong, sir. That is one thing I have submitted. We have specifically said
Blood grounds number affidavit. Page 10. Page 10 are the grounds. And all these grounds, whatever I submitted now, it speaks of that even in respect. Ground number E, even the royalty amount covered by those allotment letters, which speaks of levy of interest, the same cannot be levied at the rate at which it was levied. In the grounds, I am just pointing. Now, your lordship may take page number, next page, Milo, ground number J. We have given all the grounds or why we are challenging it. And ground number K, your lordship may see, because that is the stress and that revised demand notice of 7th respondent dated 23/5/2005 for an amount of 10,29,016, 29,16,440 issued after partly allowing the contentions of the petitioner company still suffers from the infirmities mentioned above in clauses 5 to 8. That's what I wanted to draw your lordship's attention. On these grounds, we are challenging even the demand notice of 10 crores 29 lakhs. Whatever I have submitted, I do not want to repeat it. But these grounds, very clearly, we said it included, they have not taken 50% of the concession given royalty amount. All these things were not taken. These are the grounds. So in view of this, my lord, I submit that unless this particular the 30 crores demand notice is to be rather revised, taking this 10 crores 29 lakhs, even 10 crores also is to be revised, taking our objections into consideration. That is my submission.
What is the provision for levy of penal interest?
That has been stated in my counter, but there is a proceeding that has been issued by the Principal Chief Conservator of Forest, stating that
provision either under the agreement or statutory.
The agreement, I should concede that there is no such penal interest.
No provision.
Only the interest annum is provided.
And so, and this thing, what is hard?
Hardwood. It is an admitted fact that
no provision for interest.
Even the writ petitioner himself in the affidavit has stated that there was only an oral agreement between the parties.
So no provision for levy of interest, right?
No provision for, there is no agreement at all.
So then how can you this thing? That's the.
My respectful submission is, this particular statement shows it is only with regard to bamboo supplied, not with regard to hardwood. Subject to correction, your lordship.
No, but
hardwood is in the second page.
There.
There are two.
There, so, Mr.
There are
two things are clear that this thing on hard wood, you cannot levy interest, and for this thing bamboo which has been supplied, there is no provision for levy of interest, though you can levy interest, right?
But insofar as bamboo is concerned, there is an agreement, there is a clause.
No. Bamboo is concerned, there is an agreement, there is a clause providing for levy of interest, but there is no provision for penal interest.
Yes, ma'am.
So penal interest component has to go.
Yes.
Right. And then so far as hardwood is concerned, there is no provision for interest.
Yes, ma'am.
Right. There is no stipulation between the parties.
Yes, ma'am. There is no agreement, except saying there is an oral agreement.
Taking into account these facts, you issue a fresh demand notice.
Very well. We will issue.
Right. What is fresh demand?
Will issue
fresh demand notice. In this writ petition, comma, the
Mm.